I'm calling to order this hearing. This is a public hearing of the Committee of the Whole of the Council of the District of Columbia. I'm Phil Mendelson, Chair of the Council and Chair of the Committee of the Whole. Today is Friday, January 30th, 2026. The time is 11:55 in the morning, and we are in room 412, hearing room of the Johnny Wilson Building. This hearing is being recorded and is available on the council's website, www.dccouncil.gov. The subject of this hearing is illegal construction enforcement, gaps and recommendations. The mission of the Department of Buildings is to protect the safety of residents, businesses, and visitors through permitting, inspections, and code enforcement. One of the ways in which the department carries out this mission is by responding to complaints of illegal construction, such as performing construction work without a permit, performing construction work outside of the scope of a valid permit, and so forth. Yet, over the past several years, the committee has received numerous complaints from residents about the department's responsiveness, timeliness, and enforcement actions regarding illegal construction. I could restate that the committee has received numerous complaints from residents about the department's lack of responsiveness, untimeliness, and poor enforcement regarding illegal construction. In light of these complaints, the committee has spent the last several months analyzing data from 50 illegal construction complaints for which a stop work order was issued, as well as standard operating procedures, that is, analyzing standard operating procedures, training manuals, and other relevant information. And the committee staff has prepared a report that will include a list of findings and recommendations. The report was released to the public last week. And so there's been some opportunity for folks to look at the report, the draft report, and to maybe include in testimony or statements submitted for this hearing, some comments on the draft report. The purpose of today's oversight hearing is to hear from the public and government witnesses about the findings and recommendations in the report, as well as other ways to improve the department's enforcement of permitting requirements. I will add that over the years that this committee has had oversight over the Department of Buildings and its predecessor agency, the Department of Consumer and Regulatory Affairs, the hardest part of our hearings has been testimony that has complained of damage done as a result of illegal construction on neighboring properties. Homeowners who've had walls collapse in their own homes or have had serious structural damage done to their own homes. This is something for which they're not at all responsible, and yet this has been done to them. They're the victims of illegal construction. As well, there have been some complaints with regard to buildings that were not built according to the building code, which is to say not built in compliance with the permit, and that the tenants or homeowners, and I'm thinking specifically of one building on Georgia Avenue, which is homeowners, have found that they purchased in a building in which the construction was so shoddy that there's a question of whether the building will remain safe for as long as they hoped when they bought into the building. Illegal construction is a serious problem, and the department needs to be aggressive in enforcement and on top of what's going on so that it minimizes, as to the greatest extent possible, any construction that is without a permit or construction that is outside the scope of a valid permit. We have 15 witnesses before we get to the government, and I'm going to call them half in two groups of everybody's virtual. I'm going to call the witnesses in two groups. But first, I'm going to recognize Councilmember Fruman, who I believe is here online. Councilmember Fruman?
Thank you very much, Chairman Mendelson. Illegal construction is indeed a real challenge. We hear about it all of the time, unfortunately, and it is the cause of enormous frustration when it arises. I going to largely forego an opening statement here and look forward to hearing from the witnesses today.
Thank you, Councilmember. Chuck Elkins, who's an ANC Commissioner with ANC 3D 01, Martin Holmes, David Maloff, Mimi Noorani, Lauren Esrock, Sam Bitar, Darinka Kolimovic, or Kolimovich. This person is president of 4022 Georgia Avenue Homeowners Association. While we're waiting for everybody to get on, oh, I see Councilmember White before the first witness starts to testify. Councilmember, do you have an opening statement?
I do, Chairman, a brief statement. Thank you, Chairman Mendelson, and I, want to say what a lot of people know, which is that illegal construction is not a paperwork issue. It is a public safety threat. It's a trust gap and a budget drain that we cannot afford to ignore. It's something I see too much of in my work as Housing Committee Chair. When a developer cuts corners, it's not just a violation of the code. It is a risk to neighbors, to workers, and to the integrity of our housing stock. And when the enforcement fails, those risks multiply because bad actors learn that rules are optional. Residents across the district have seen this firsthand. They report excavation next door that cracks their foundation or rear walls ripped out without a permit. They call DOB and too often they wait, sometimes for weeks, sometimes for months, and even when the stop work order is posted, nearly half of those orders show no evidence of a follow-up inspection. That means that work can continue unchecked and neighbors are left wondering whether the city is serious about its own laws. The committee's investigation makes clear the pattern. Inspectors are sent into the field without adequate training, and there are only 5 illegal construction inspectors handling thousands of cases a year. The department's own KPIs is to inspect within 7 days of a complaint, yet the report shows that we're hitting 71% with some inspection delays, 69 to 104 days. And when enforcement reaches the next stage, over half of the notices of infraction are dismissed, often because of defects or delays. Even when violators are found liable, fines are reduced or suspended. This is not just about safety, it's about money. Every time illegal work proceeds unchecked, the district ends up paying later for emergency inspections, for litigation, for repairs when buildings fail. We already see this on the housing condition side, with $56 million in unpaid fines, fewer than half of the violations verified as fixed, and collection rates that hover around 10 to 12% through the standard route. That's what happens when enforcement lacks teeth. And if we don't stop illegal construction early, we will keep spending public dollars to clean up private negligence. We know that where this road leads if we don't act early. Illegal construction today becomes unsafe housing tomorrow, and a backlog of fines the city may never collect. That's why I've introduced legislation to strengthen enforcement tools. The Lien Act of 2026 will let DOB place liens and recover abatement costs faster, so chronic violators feel real pressure to fix hazards. And the Strong Homes Amendment Act will expand receivership and injunctive relief for the worst cases so that tenants are not left living in danger while owners stall. These bills share one goal: make delay expensive and compliance automatic, because prevention is cheaper than repair. So today I'm asking the Department of Buildings for candor and for urgency. Why are inspections delayed? Why are stop work orders not verified? Why are NOIs defective and dismissed? Why are repeat offenders not tracked? Why do licensed contractors who break the law face almost no professional consequences? And what tools does DOB need to fulfill its duty to protect district residents? These are not technical questions. They are questions of accountability and safety. Residents deserve better. They deserve a city that enforces its own laws swiftly and fairly, and they deserve a housing code that is respected. So I want to thank you again, Chairman, for holding this hearing. Thank all of our public witnesses, and I see some ANC commissioners as well for being with us. I'll be jumping in and out, but this is a very important hearing. Thank you, Chairman.
Thank you, Councilmember. So we will turn now to Mr. Elkins, Commissioner Elkins.
Thank you, Mr. Chairman. Let me first thank you for holding this hearing and for the committee's report on DOB's enforcement program. After 25 years of running regulatory programs at the Federal Environmental Protection Agency, I can state with confidence that when there is a government rule with no meaningful enforcement, these rules act as a license for cheaters to make lots of money at the expense of the public and their competitors. At EPA, we didn't just issue permits that appeared to conform to our regulations and then pat the chemical company or the power plant executive on the back and say, be good. We checked these applications carefully and then went out in the field to make sure that the huge amount of money that they could make from non-compliance compared to their competitors did not overwhelm their best judgment. As your report illustrates, I don't think DOB has come to terms with this similar reality in the DC building construction area. I believe your report has uncovered only the tip of the iceberg, and the committee's work cannot be considered complete until it looks at the entire system. You're familiar with our group, which we call Build Safe DC, made up almost entirely of individuals who have suffered significant personal loss and pain and suffering, because in our view, the Department of Building systems for preventing these losses is totally inadequate. We tried in our report to look across the whole system, and we believe the committee should do so also. The DOB permit review program should not give these incompetent or rogue builders a permit in the first place. But when DOB does, the department officially transfers the responsibility of knowing how to carry out this dangerous work and then executing the work in the field to the permit holder, with totally inadequate systems of inspection to ensure that the dangerous things do not happen to the neighboring housing. When something goes bad, the neighbor is left to cope for himself because of the inadequacies of DOB's neighbor notification system, the insurance requirements, OAH's clogged docket, and the overworked court system. DOB repeatedly states that their permit review is focused on making sure the builder's permit application meets code. That's important, of course, but this narrow view of the department's responsibility ignores the fact that in construction, there's a lot of money to make if you cheat or cut corners, and DOB should shoulder much more responsibility that ensures that this doesn't happen. And here's the important point, Mr. Chairman. They have decided not to take this kind of responsibility as a matter of policy, not just because they don't have the budgetary resources. The consequences for the builder for cheating, cutting corners, or incompetence are very small. A good example is in the death of the worker at V Street last year. The builder paid a tiny fine. DLCP might suspend the license, but I'm not holding my breath. And now the same builder has gotten a DOB permit to finish the building. Why should DOB trust him to do it safely? Well, maybe they don't actually trust him, but with their policy that all the responsibility rests on the builder and the third-party inspectors, if something goes wrong, well, it's not DOB's fault. If you think I'm being too cynical, just read the department's post-mortem report on V Street. They took absolutely no responsibility for that death. Let's hope another worker does not get killed by this worker. But with all that, there may be some light at the end of the tunnel. I'm happy to report that in response to our 70-page 36 recommendation report on this problem, which you have, and I've submitted here to the committee, DOB has admitted they have a problem and have moved to fix it. They have established an enhanced review of permits that involve these kinds of dangerous structural procedures. Built into the review is the objective of also enhancing the actual implementation at the site once the permit is approved. This all sounds good as it goes, and I congratulate the department for making these changes. But on the other hand, all this could turn out to be just a repackaging or rebranding what DOB was supposed to be doing previously. I can't tell. So will this enhanced review make a difference? My response is, to borrow from President Reagan, trust but verify. A good first step would be to give some inspection resources to the department in the next budget, Mr. Chairman, but that's only a start. There has to be a lot more. This system is broken. This is not a regulatory program that one would normally call such. Thank you, Mr. Chairman.
Thank you, Commissioner Elkins. Martin Holmes?
Yes, thank you, Chairman. Thank you, council members, and thank you for hosting this important hearing today. I am one of the many DC homeowners whose property was damaged by adjacent construction. I've spent tens of thousands of dollars taking my case into the DC court system, and it's still underway with no satisfactory ending in sight. There were a plethora of problems leading up to the damage where my basement was flooded. Upon further investigation, we discovered structural anomalies at the property next door that call into question the structural integrity of my own building along the party wall. Some of the problems at the adjacent property relate right at the beginning to the submission of drawings and plans to DOB, which DOB approved, but then the adjacent property owner deviated from those plans. And homeowners, myself, would repeatedly flag these deviations to DOB, expecting and hoping for them to act. But in this case, they failed to act until after my property was already flooded. So enforcement is the one kind of key protection that we small homeowners have to protect us from the corporations that are making a lot of money and incentivized to cut corners and jeopardize their neighbors next door. The third-party inspection program has varying degrees of quality and regularity, as well as performance in that program. And then often the structural engineers that are stamping drawings are doing so without having adequate calculations in place. Some of my property, since my property was damaged, I do appreciate that DOB has taken some steps to enforce and resolve the issues at that adjacent property. But the partial enforcement is a little too little too late, and the problems still exist. I flagged roughly 2 years ago for DOB the continued problems, including when DOB sent an inspector, Hassan Abbasi, to look at my building and look at the structural pits that had been dug out to show the foundation of my property. And he himself flagged that there were structural concerns. It then took 2 years before DOB acted upon that. In addition to that, we have flagged for several years the fact that the adjacent property exceeded the height and story limitations allowed by zoning. Again, it took DOB over a year before they came and enforced that. And although I am happy that they eventually issued correction orders for these violations, they then immediately undermined their own order by granting permits to allow for new construction at the property that they found deviated from the plans, granting new permits and turning a blind eye to the fact that the physical violations on the ground did not match the plans and paperwork that they were submitting to DOB for new permits. So it's a farce. It's imaginary. DOB approving imaginary compliance based on paperwork, but ignoring the ground situation. And that is, again, why enforcement is so key. It failed me. I am hopeful that we continue to gain some traction, but DOB really needs to wake up to this. I am very hopeful and happy about the council and DOB's response to the council's investigation of these problems. I'm hopeful that they will provide resolutions, but it will take time. We need metrics and continued strict oversight to ensure that DOB is improving to protect the neighbors and the little guys. Thank you.
Thank you, Mr. Holmes. I do not have a copy of your statement. If you could provide that, please.
I will by the end of the day. Thank you, Chair, and I'm sorry for the delay.
That's okay. And what's the address of the property next to you that has the illegal construction?
Okay, the adjacent property is 1212 Oates Street, OATES, Oates Street Northeast. My property is 1210.
Okay. Thank you. David Maloff?
Good morning. I am David Maloff, a 43-year resident and past president of the DC Federation of Citizens Associations. At that time, the Federation was an umbrella group of 27 neighborhood community civic citizens associations in every ward. Thank you for allowing me to testify today. Thanks especially to our steadfast chairman, as well as Mr. Blaine Stum on the committee staff, and Honorable ANC Commissioner Chuck Elkins for their hard work on the matter of illegal construction that should also include often poor DOB permitting and inspections right up front. All of this can later lead to contractor negligence and damages affecting adjacent property owners, called APOs officially under the law, and endangering usually unwitting general public and construction workers alike. There's much more to cover, but please allow me 3 related points today. First, several clerical process improvements by DOB's honest records maintenance staff can stop cold in its tracks the pathway to endangerment, injury, and financial losses long before enforcement is sought at the Office of Administrative Hearings. Let me be clear about the term illegal construction as I see it. Once permitting, reviews, and approvals, critical safety reporting, and third-party inspections processes deviate from the code and settled DOB-required official procedures, the project clearly and immediately is in a state of illegal construction until the situation is rectified. Thus, mitigating illegal construction begins day one with better permitting scrutiny and scrupulous yet simple recordation. I can give examples. What is occurring now is an inspector is finally called out after someone picks up the phone, after noticing a dangerous situation through a possibly shrouded, usually fence line. And then an inspector late in the construction process writes gradually, eventually, a stop work order and a notice of infraction. Second, the highly effective neighbor notification program that cynically was ripped away from protecting abutting neighborhood APOs and the general public in October 2022 needs to be reinstated in full, pending the Construction Codes Coordinating Board, the CCCBs, adopting new improvements into the construction code, and that process is already in progress this year. This can easily be done by administrative fiat, just as it was ripped away in the same manner in full. Neighbors need to be notified about dangerous construction in time to know specifically what danger lies ahead and to have a voice in mitigating it prior to digging and abutting alterations being made underneath, attached to, or above their homes. Third, today's report repeatedly states the need of the Office of Administrative Hearings to be better staffed and more responsive to address DOB-initiated enforcement cases and DOB's needs. Yet DOB itself chooses to be reckless in defiance of 3 active OAH court orders that I hold in my hands from different judges issued against the agency, from thorough and impressively articulated court decisions, all regarding reckless and dangerous construction DOB allowed in total silence to my concerns and promised resolution prior to permitting twice. DOB has said in the first order that it's closed and it's not. None of the judge's order has been obeyed by DOB. The third order arrived 70 days ago and DOB continues to be silent in complying with it. What's it going to take, Mr. Chairman? I heartily suggest the committee take time this morning to address with DOB officials sitting before you the need to review and document, similar to today's report, all the low cost and high impact ways during permitting, neighbor notification, and key records keeping that dangerous construction damages and disasters can be proactively mitigated at low to no incremental cost, all in addition to the invasive enforcement that takes place much later in the process that is being discussed today. Thank you.
Thank you, Mr. Maloff. It's good to see you again. I don't have a copy of
sir.
your statement, which I assume you'll submit later.
I shall.
Thank you. Mimi Noorani, I believe, is not here. Lauren Esrak?
Yes, hi. Thank you, Chairman Mendelson and members of the committee for this opportunity to testify today. My name's Lauren and I'm the president of a 2-unit condominium association here in the district. I've testified previously, but as a reminder, I, along with the other unit owner, were first-time homeowners when we purchased our units almost 8 years ago for a combined $2 million, relying on DOB's inspections to ensure compliance with DC code and law. I won't go into the details again, other than to say DOB's failures to conduct accurate inspections and ensure the building was built to the approved plans has resulted in an almost 8-year legal and financial nightmare. I applaud the committee for taking this first step in commissioning the postmortem. However, I urge you to ensure the recommendations are not only implemented, but more importantly, DOB provides a transparent way to accurately measure progress. As Chuck mentioned, this report only addresses a small piece of the larger problems. As homeowners in DC, we rely on DOB's checks and balance system to ensure developers, GCs, and other homeowners have built in compliance with DOB's codes and standards. As we read in the report, the shortcomings of the agencies have heavily contributed to the unfortunate and egregious situations, mine included, that have been brought before this committee in previous years. Thank you for this opportunity.
Thank you, Ms. Esrock. I do have a copy of your statement. Can you remind me of the address?
I live at 240 Q Street Northwest.
I'm just making a note of the properties at issue. And actually, I forgot to ask Mr. Maloff. It was a neighbor who there was illegal construction. What was the address?
Yes, Mr. Chairman.
What was the address of the neighbor with the illegal construction?
1713 Q Street, an abomination at DOB and now being discussed at HPRB as well.
Thank you. Sam Bitar. Samer Bitar? We'll keep moving. It looks like he's online. Darinka Kalimovich?
Yes, Komjanovich, you got it. 1 second. All right, well, good afternoon, Chairman, members of the council, fellow residents. My name is Darinka Komjanovich. I am one of the homeowners of 4022 Georgia Avenue, one of the Department of Buildings' own high-risk properties in a building that was entirely illegally constructed. Some of you may know it from the Washingtonian article, "They bought a new DC luxury condo, it could collapse." Over the last year, there has been renewed attention on DOB's failures. The formation of the Resident Coalition Build Safe DC, a residents' report urging DOB to fulfill its core mission. Shout out to the members. Followed by DOB's responding to that report, outlining what it intends to do. The tragic death of construction worker Edgar Lopez on V Street, further emphasizing DOB's gaps, leading to residents to once again urge DOB to act, which then once again was followed by another DOB report outlining what DOB intends to do. The point is, residents have listened to years of open-ended commitments and polished narratives, but on the ground, nothing meaningful has changed. And that is because illegal construction in DC is not a policy mystery, it is an enforcement failure. Let me be clear about what my building represents. A quick summary. I'm sure you've heard it before, but my building was not poorly built. It was not a complex case. It was an entirely illegal built in violation of zoning and building code, and yet still permitted, inspected, approved, and occupied. It has no lateral bracing. It sways in the wind. It has dozens of severe violations and clear documentation of missing and fraudulent inspections. And any competent oversight system would have stopped this project before it became someone's home. Yet DOB approved it anyway. And when the dangers became undeniable, DOB did not enforce the law. Instead, DOB did what it consistently does. It shifted responsibility to the victims. We were told again and again to hire our own engineers, produce our own reports, spend our own money, and prove to DOB what DOB's own approval process had already certified as safe. That is not public service or oversight. That is simply institutional self-protection. When DOB fails to enforce, the cost does not disappear, as many of us here know. It is simply transferred to homeowners, to neighbors, to workers. Developers simply point to DOB's approval to escape liability, and lawyers use DOB permits as shields. Residents are left funding enforcement through legal fees, engineering reports, and years of litigation just to make the city acknowledge what it already approved. DOB's recent postmortem following Lopez's death emphasizes yet again process and future plans, but they avoid the central issue. There is still no automatic mandatory enforcement when illegal construction is discovered. Let me repeat, there is still no enforcement when illegal construction is discovered. Stop work orders disappear with modest fines, as we've heard. Penalties are discretionary. Repeat offenders continue operating. And even in cases involving structural danger or death, enforcement happens only after the catastrophe, not before. V Street could have been and should have been a line in the sand, but it became another report, one that's heavy on process and very light on responsibility. Based on the homeowner's report submitted, and the echoes across the district in a gathering such as these, we are asking for enforcement, not aspirations. We are asking for simple things like mandatory stop work orders when illegal construction or structural danger is identified, automatic enforcement triggers tied to violations, public identification and restriction of repeat offenders, independent technical authority to override unsafe approvals or really any technical expertise at all, and an end to resident-funded enforcement. These are not radical demands. These are the bare minimum for a functioning enforcement system. And until these changes exist, no report will prevent the next collapse, the next displacement, the next death. Let me just end by saying, we are not going away. Homeowners across the district are organized and paying attention. We will continue to show up and engage until this council enforces oversight and not paperwork. My home should have never been built, and the fact that it was and that residents were left holding the risk is not a one-off failure. It is systemic. And we are here to make sure that it does not happen or continue to happen. Thank you.
Thank you, Ms. Komunovich. Wade, did I get to Wade Teal? I didn't, did I? Okay, I think we stopped there. Let me see if Sam Pitar has reappeared. Excellent. Please proceed.
Thank you, everybody. It's been great to hear everybody's testimony today, and I apologize here for the bad video, but hopefully my audio is coming across.
Yes.
I submitted my testimony in writing. I really want to focus on three things that I think are actionable, that I think DCLP and DOB can do to reduce a large percentage of the impact that these issues have on DC homeowners. I am the neighbor to the V Street project that's been brought up many times. I live next door to that project. My home was built in 1870. It's constructed of antique and obsolete methods of unreinforced brick. I'm a design professional. you know, to become a licensed professional, you have to go through years of school. You have to have at least 4 years of apprenticeship under licensed architect. You have to then pass 7 rigorous exams. Um, you have to be so knowledgeable to become a design professional. That includes becoming an engineer. You know, to become a gas fitter or a plumber, to become licensed as an electrician. There is a process to doing high risk construction. There is a process to being a professional who's involved in life safety issues like designing a building. I mean, even designing the smallest of structure is the smallest structure. You can think of a shed as a life safety issue. So it is really amazing to me that anybody can get with a clean hand certificate and bonding become a Class A contractor, Class B contractor, Class C contractor, and take on the kind of work that is involved in building the kind of condo structure that's swaying in the wind, or that the builder deviates from the plan and causes an unintended collapse and takes a person's life. I mean, we have a systemic problem here in licensure. We have a systemic problem here in DC with who can do the kind of construction work that is really high risk. So when we're talking about below grade work and underpinning, which I think is a very impactful type of construction work, I believe these kind of contractors really need to be licensed and closely scrutinized. DCRA DOB, excuse me, already puts out requirements for underpinning contractors in terms of their experience and their skill level. Yet nobody's really vetting that process to make sure that they're certified to do this kind of work. So I think the first actionable item for me would be that contractors doing underpinning work, below grade work, structural supports to adjacent properties, they need to be certified in order to be able to do that kind of work with enough experience shown to qualify. In the meantime, DOB could at least require contractors to submit their qualifications and to provide those to neighboring homeowners as part of the neighborhood notification process. Simple, and I think very reasonable, and I think would prevent so much from in terms of damage to existing buildings, because there are many very qualified, underpinning contractors out there, just not the one that worked next door to me. DOB enforcing DC Law 25-243 of protecting adjacent adjoining property owners from construction damage. That act requires them to get insurance that covers adjacent structures, so that somebody who is just innocently owning a home next to a big project is at least insured. Okay, so at least there's some umbrella of coverage that might protect their property. I think that the mayor began that initiative. I don't know how it gets enforced. I don't know the complexities around it. But in a city where almost every property is abutting another property, and where we have so many historic structures, I think that's a critical step to take. I think the third piece was I think what Council Member White referred to, which is to publish and make available information where licensed design professionals like myself, or licensed contractors, anybody doing work in the district, if there has been disciplinary action against them, if there have been citations, if they have been involved in projects that are problematic, that information be publicly available. Because if you're a neighboring homeowner and you're buying a condo and you know who the builder is, yet you have no idea where they came from, it's some LLC that you don't have any history on. Every one of these projects is a different sole member or LLC situation. They're just hard to track, even for somebody like me who has all the resources to be able to do that. I found myself in the dark as to who it was that was actually doing this project next door. I think these are public safety issues. I think they're within the scope of consumer protections that DCLP is in charge of, and I hope those 3 points are helpful in moving this forward. My written statement has a lot of other detail, but I think everybody here has articulated the frustration.
Yes, Mr. Bitar, I'm going to cut you off even though you're near the end because you're a couple minutes over your time.
Yeah, thank you
And
very
I
much.
do have your
I appreciate
statement.
it.
Thank you. I thank each of you for your testimony. I had one question for Ms. Kaminovich. I think I'm pronouncing your name at least close to right. You recommended an independent technical authority with the power to override DOB approvals when structural risk is present. What would that look like, an independent technical authority?
I mean, even if we're just saying a technical authority, just someone who is an expert, basically exactly what Sam was just saying. The expertise needed to be able to do this kind of work is currently missing on the staff.
Okay, that explains that. Thank you. I don't have other questions for you all. A couple of you did not submit statements, if you would, please. And I thank you for your time and for your testimony. And even though I'm not at fault for this, I apologize that you've had to go through these experiences with the illegal construction. So thank you for your input. You all are excused. I'm going to turn to the rest
you.
of the witnesses. But,
Oh,
oh, I'm sorry.
Councilmember-
No, you're not excused yet. Councilmember Fruman. Gosh, I
Thank
was
you
getting
very
ahead of
much,
myself.
Chairman Mendelson.
Yes.
I want to express to the folks who are in buildings that have been damaged or compromised by these practices, terrible. Feel for you. And as the chairman does, want to find a way to be helpful and avoid these things going forward. I have a couple of questions for Chuck Elkins. There's themes that run through all of the testimony, but Mr. Elkins, or good to see you, Chuck. You referenced the report you did, the 72-page report you did with a long list of recommendations and findings. And you said that there has been some constructive response to that. I'm curious, the last time that we spoke about this, you'd reviewed the response from DOB. You thought that it was constructive in many ways, but there were still open issues. You hope to be in a back and forth with the agency. And I don't know where it's gone from there. Have you been able to engage with the agency on their response to your findings and recommendations?
Well, yes and no, council member. On the one hand, when we had that response in November, we hope to have that interaction then with the agency so that we would be much better prepared for these hearings. And that meeting did not get set up. I don't know all the causes. Then at the last minute on Tuesday, seeing this hearing coming up and realizing that, boy, we really missed that hearing, I did ask for the hearing, for a meeting again, and we did have one on Wednesday, and we did hear about their change in how they're trying to do the permit program. And as I testify, it sounds good, but as a layman, I can't, and of course I'm not inside, I can't really see. And I think you've heard some of the other comments here today that makes one want to look very closely at that. And then with regard to the rest of their response to our report, which we didn't have time to really talk about, they basically are saying we're happy with the status quo. We don't want to make any changes. So there's a lot of work to be done. And if the department is willing, I think it would be helpful to have more discussions. And quite frankly, I would think it would help to have committee staff present to just sort of move things along and really get to the key points. Thank you.
So I think this whole discussion, but that piece of it maybe underscores the Heisenberg principle, which is, one of my favorites, that the act of observing changes the phenomenon observed. So there was going to be a hearing, and because there was going to be a hearing, maybe that shook loose and got meeting. I think hats off to the chairman and to the committee and the committee staff for focusing on these issues, because that's how change can come. And applaud the chairman and committee staff for the report that they have done. One of the themes that comes up a lot is repeat offenders. And I think part of what the recommendations in the draft report are that there be a unique identification for every property owner and contractor so you can track things better, and that there be a protocol for referral to DLCP. And those strike me as very constructive suggestions. I wonder, in your view, whether they are adequate or there are other things you would like to see done in that space of trying to get at repeat offenders.
Well, if you're speaking to me,
Yeah.
well, I think that identifying these people is important, and then giving them very special attention. I think the department has said they will give these people attention, but I think here's I think the more generic problem that is not addressed by that, and that is that if you're not a general contractor and don't have a license at stake, you can be a builder or developer, and it really are no consequences. And so they basically, although I don't think DOB is going to deny these people a permit, as from what I'm hearing. They're going to listen and watch them more closely, but that doesn't keep them from getting a permit. They get a permit. They as the builder at V Street essentially gets away with not much penalty at all, and now is building away. So I just think there's a whole set of recommendations that could be made. I've heard good ones here today, but just doing a couple of things that are reflected in that report, yes, I think those should be done, but the committee shouldn't stop there. That's just a drop in the bucket for what I think needs to be done, I'm sorry to say.
Okay, Mr. Chairman, I wonder if you'll indulge me one last
Sure.
question. So again, Mr. Elkins, because you have been, we've been in conversation on these issues for a while, so I look to you on these things. There is a fair amount of reference in your testimony about DOB accountability, and I wonder what that means. I mean, DOB accountability is city accountability, and maybe what you're suggesting is financial liability for failures in the process. But what do you mean when you talk about DOB accountability? What form does that take?
I think, well, let me turn to what your testimony you're going to hear soon from the department. They had 6,189 illegal construction inspections in last year. 2,604 active stop work orders, and 2,201 unabated violations. They're proud of the fact that they have a 64% abatement on life safety violations. Now, if you have a department that comes here and testifies with pride that they've improved their performance and they've gotten all the way up to 64%, there's something wrong here. I think it's a matter of what they're not being accountable to the neighbors, and I think that there needs to be a reset of what is expected of the department. When this department was created, the council took a special step to create a enforcement official who would be looking at the strategy for enforcement. As far as I can tell, that official has very little to do with the construction part of the agency. He works primarily on tenant enforcement, which is very important, and he works on vacant blighted properties, but not so much on construction. So there needs to be a reset of what is expected of the department, so that when they report, they'll be reporting 99% case of abatement of life-threatening violations. I'll
Okay.
stop because I think my colleagues probably have a lot to, they'd like to offer.
Well, I think I've gone, I don't know whether there was a hand raised of somebody who wanted to
Yeah,
respond.
Ms. Esrock has her hand up.
Yeah,
Okay,
I would
so-
love to respond. I mean, again, I'm not necessarily a victim of construction next door, but I have previously testified that, one of the recommendations I would love to see in terms of DOB and the city taking accountability is when you look at what happens in Virginia or Maryland, those departments, a percentage of the permit fees actually go into a fund that individuals like myself, Darinka, could have accessed had we lived in Virginia or Maryland and had this happen to us, instead of spending, hundreds of thousands of dollars out of pocket, trying to use the court system to help us.
Okay, thank you for that. All right, Chairman Mendelson, I am well over, so I turn it back to you, and thank you for allowing me to go over.
Thank you, Councilmember Fruman. I have no more questions for you all, but again, thank you for your time and your testimony, and sorry that you've had these experiences. You all are excused, and I'll turn to the remainder of the witnesses. Wade Taylor, Eric Jones, who is Vice President of Government Affairs for DC Commercial at AOBA.
Thank you.
Taylor Castellanos, who's Executive Director of Who Speaks for Me. Tina Batchelor, Nicholas Thomas, Valerie Jablow, Rebecca Miller, who's Executive Director of the DC Preservation League, and Mommy Preston. And I thought I was done. Jonathan Hertz. So give me a second here. Is Wade Taylor here? I did not see him. Eric Jones, you're next up.
Good afternoon, Chairman Mendelson and members of the committee. My name is Eric Jones. I am here today as a fourth-generation Washingtonian and Ward 4 resident who has the honor of serving as Vice President of Government Affairs, DC Commercial for the Apartment and Office Building Association, Metropolitan Washington. In the matter of time, I won't give the full background of AOBA, but we've been around for more than 50 years, and we represent about 60 to 70% of all apartment units here in the district and well over 75 million square feet of commercial space. I'm here to testify today in support of the changes made, but also in a negative way because unfortunately, I'm hearing folks testify who over and over again have made recommendations. And the scary part is none of them have worked in the proper industries that are being targeted. I've said, and I'm going to talk about certain members of this council who remain nameless and some of the folks who've testified today. When DCRA was broken up into DLCP and DOB, I was a construction lobbyist. I've been lobbying for construction, property owners, and managers in the district for 2 decades. Everyone who is seen as the folks who do this correctly all said that will not solve the problem. And we were yelled at and told we were wrong. The millions of dollars that was spent to stand up 2 separate agencies, we all recommended should be spent to hire more inspectors, include new programs, and we were all ignored. Now we're looking at this again and fast forward several years later, and we're hearing the same folks have the same conversations, but the people who aren't at the table are the folks who are doing it right. The contractors who do the majority of building in the district aren't included in conversations. The developers who are doing good development in the district aren't included in conversations. The property owners who are doing this the correct way aren't included in the conversations. And yet again, we're hearing more recommendations that exclude the folks who know how to do this correctly. And it's very problematic because we're not dealing with the underlying issues. Within my testimony, I have 6 recommendations, which I'll cover. The first is on the referral process to DLCP, and those 3 recommendations are simple. When designing a referral process to DOB and DLCP, the agencies should ensure that all relevant information provided in the permits applied for and approved by DOB matches the information within DLCP. We've heard folks talk about this. You shouldn't be able to apply for a permit if DLCP doesn't have your licensing information. That's really simple. establishing a working group with business communities, the business community, trade organizations to review and monitor best practices. Someone just talked about what works well in Maryland and Virginia, but when the folks who work in all three jurisdictions make recommendations, they haven't been taken. Additionally, and this is something that no one likes to talk about, the general contractor program through DLCP was not funded. So we've had conversations about expanding general contractor licenses and standing up new programs. Yet again, they haven't been funded by this government. As it relates to proactive enforcement strategies, we have three recommendations. As highlighted in the council report, illegal construction in large part takes place in single family and small to medium-sized family properties. Yet, when we talk about changes, we talk about broad sweeping. This should not be the case. Let's focus on the areas that have problems. Secondly, in focusing on teams, specifically property types, we believe it's more important than new strategies to target illegal construction and come up with ideas, implementation strategies that actually target those high-risk areas and develop programs towards those. Last but not least, we don't have a rapid response team to deal with these high-risk areas. In every other criminal aspect, whether it's drug use, it's murders, whether it's running red lights, there's a rapid response team that sets up in areas to highlight those key areas. We don't do that in illegal construction. It doesn't make sense, and yet we're having these same conversations because we're not looking at what's worked in other jurisdictions. In a matter of time, I'll end there, and I'm available for any questions you may have.
Whoa. Thank you, Mr. Jones. Taylor Castellanos. Tina Batchelor.
Yes, sir. I'm here.
Please proceed.
Hi. Good afternoon, everyone. I'm sorry it's so dark in here. My name is Constantina Batchelor. I live next door to what was the Eagle Academy illegal build of their school. Not only was the end product, I think is probably problematic. I've seen all kinds of issues with the school. The first half of the school that was built illegally had flooding and kind of fires and just all sorts of issue. But this is a school. It's not even if it was a home. And so I petitioned to have the laws change where if any school, whatever type of school, private, charter, as with public schools, there needs to be impact plans, feasibility studies, and all of that type of thing. But of course, the charter school entities came in and tried to shut me down. What I saw during the construction, it was everything across the board was illegal. Not only the construction itself, but who was building the school, when they were building, the impact to the neighbors, my home, and the home behind me. We're downhill from the school. Now my property has shifted. It was shifting then. No one was watching. No one was inspecting. And to add insult to injury, the school was passed off to Lee Montessori, and you all allowed them to build a second big structure in this small space. But the underlying issue is that the soil that the school was built on couldn't support the first school, not only the second. So what I found during my trek around all of the agencies to help to find some kind of help was that a lot of the people within the agencies that's supposed to protect citizens were leaning heavily on the businesses and their what they were going to get out of the situation. And frankly, some of the people who were supposed to be inspecting were just cozy or too cozy with the contractors. The citizens and the homeowners weren't being taken into account. So I would like, and we're the capital of the world. We're the nation's capital. How does this happen? You can't build illegally down on the mall, but you can go into the parts of the city where the neighborhoods are and just build and do all sorts of kind of thing. So one of the things is I would like to see stronger the penalties because they really laugh at them. And a lot of them were waived. If you could, strengthen with your pen to be able to have something more forceful. People should, people have died. My neighbor, she's 70, she's behind me. Her home was impacted during the first build. She's still displaced. We are really being negatively impacted. So penalties need to have not only fines but some jail time. If you're going to build a structure illegally, it should be torn down. How do you build something illegally and then let it stand? Maybe they should take the cost and tear it down, not turn around and give them permits to occupy and those things. We as citizens need your support. And so write some legislation that protects the citizens, that have harsher fines and hold these people to a higher accountability. Thank you.
Thank you, Ms. Batchelor. I don't have a copy of your statement. If you could provide that.
Yes, sir. Nice to see you, Chairman.
Thank you. Nicholas Thomas. I don't see him. Valerie Jablo.
Thank you. I am Valerie Jablo, a DC resident. The report your committee issued on illegal construction and DOB shows, perhaps inadvertently, what happens when wealthy interests buy and renovate DC properties, skirt laws, and endanger people with impunity. Here is an ongoing example. In late 2020, the historic Capitol Hill rooming house at 101 5th Street Northeast was put up for sale by its LLC owner in the wake of me and neighbors reporting it for a variety of violations, including operating without a license and improper trash management. As the property went on the market, I found trash from 101 5th dumped in my yard. In February 2021, another LLC bought 101 5th Northeast. That LLC shares a Las Vegas address with a real estate investment firm. Weeks later, this rooming house in the historic district of Capitol Hill was illegally gutted without any permit. Neighbors reported it repeatedly, yet even after DCRA documented gross violations and issued stop work orders, after police escorted workers away at least once, and after DCRA cited the owner and then said it was unable to access the building, work continued. During this time, I was photographed in my own yard by the owner's workers. Finally, months after the first report of illegal construction, DCRA accessed the property and boarded it up. A short time later, workers illegally accessed the building and resumed their work. In 2025, one of the interns rooming at 101 5th Northeast knocked at my door and asked if I had water. Apparently, the owner failed to pay the water bill. The next door neighbor's trash cans were eaten through by rats that have proliferated around unsecured trash at the property, which neighbors have reported. The last time the property tax was paid was almost a year ago, and in December, windows were replaced without necessary permits. When I reported the windows to DOB, I got an email saying that an inspection was scheduled. Then I got an email saying the inspection was rescheduled. Then I got an email saying that no violation was found. Then I got an email saying the inspection was rescheduled again. Then I got another email saying it was not in violation. Then I got a call on New Year's Eve evening from an unidentified DOB inspector who wanted to know what my complaint was. That call came a week after I sent DOB pictures of the new windows with their labels attached and with a worker hanging out of a second floor opening. Then on New Year's Day, I got email notification from DOB that a violation was found, except that I've never found anything about it in the Scout database. As two Capitol Hill historic properties were recently illegally demolished, it seems DC agencies like DOB work best for those whom the law protects, but does not bind. Consider that use of Capitol Hill residences solely for corporate purposes has skyrocketed. That may be because neighbors have been told by DOB, which is supposed to, by law, protect our historic neighborhood from such illegal activity, that nothing can be done. If you don't believe me, ask the DOB director. Unfortunately, illegal building practices pose a direct and avoidable danger. For instance, the 2019 unpermitted building of a charter school, which Ms. Batchelor just testified about, was associated with many environmental problems, while structural damage to neighboring homes was never remediated. Illegally installed two-story flagpoles at a Capitol Hill house used solely for corporate purposes are still, more than a year later, leaning dangerously over the public sidewalk. So while I am grateful for your efforts here, after endangering residents by not rigorously enforcing DC laws, DOB needs way more than recommendations. The first step is for DOB to stop prioritizing those whom the law protects but does not bind. Thank you.
Thank you, Mr. Chavelo. Rebecca Miller.
Good afternoon, Chairman Mendelson and members of the committee. My name is Rebecca Miller, and I serve as the Executive Director of the DC Preservation League, a dedicated nonprofit committed to preserving the built environment throughout our city. I appreciate the opportunity to provide feedback on the staff report addressing illegal construction, which highlights a critical issue, the alarming underfunding and dysfunction within enforcement mechanisms impacting neighborhoods across the District of Columbia. DCPL commends the committee staff for their thoughtful examination of this pressing topic and their effort to delineate the various interrelated causes of the systemic failures. We wholeheartedly endorse all of these recommendations and strongly urge continued intensive follow-up with the Department of Buildings, the Office of Administrative Hearings, and the Historic Preservation Office, which bears unique responsibilities for overseeing historic properties. It is crucial to address these resources allocated to these agencies and assess how each functions independently and collaboratively. What is needed now is a comprehensive multi-year interagency action plan to effectively resolve the shortcomings identified in the report. While our experiences with historic properties represent only one dimension of the broader issue of illegal construction in the city, they resonate with the frustrations voiced by individuals interviewed by council staff in the report. There is overwhelmingly exasperation stemming from the difficulties engaging with DOB. Many of the challenges that contributed to DCRA's shortcomings continue under DOB's jurisdiction. The city remains heavily reliant on reports from neighboring homeowners willing to advocate for enforcement rather than providing the necessary resources for DOB to conduct consistent and reliable follow-up inspections and ongoing construction projects. Nearly 30 years ago, our preservation community teamed up with the city to enhance enforcement in DC's historic districts, insisting that HPO intervene when DCRA failed to fulfill its obligations. HPO hired an enforcement officer and later two more who worked with DCRA and DOB and were responsive to complaints related to historic properties. Statutory enforcement remained with DCRA and DOB. However, in the current fiscal year, HPO lost both of its field enforcement FTEs, and their supervisor, the original enforcement officer, was converted to a compliance officer. HPO must now rely on inspections by DOB instead of directly applying its own enforcement experience acquired over the last 3 decades. So we seem to be back where we were 30 years ago and complaining about the lack of enforcement of illegal construction in historic districts. It's time for us to act decisively. We need an action plan to combat illegal construction that brings in all relevant city agencies. Preservation of our city's architectural heritage and the safeguarding of our neighborhoods depend on robust enforcement mechanisms. And I see that I have about a minute left, so I'll just take a left into my own experience as a homeowner in Bloomingdale. My neighboring property at 113 W Street has been a problem since the time the new ownership purchased it in September of 2024. It has had 3 stop work orders. It remains vacant at this time and open to the elements. I sent your staff pictures of the property. The first stop work order came after excessive badgering of Department of Buildings when the applicant had removed all of the first 4 joists. Now, these houses are 70 feet in length, so we're talking at least 15 to 16 joists going from front to back between 2 neighboring row houses. There was no notification given to us. The plans that were filed were not of the existing nature of the interior of the house. The plans that they were permitted to do was not what they were executing, and the Department of Buildings continually let them work. Finally, we received another stop work order. They then received a deck permit where they added an addition to the back of the house, which then they received finally another stop work order. The property has now been under this last stop work order since I guess it's June of last year. So this continues to be an issue, and I see that they have permits pending in the Scout system, and we've not received any notification nor have any information on what they're planning to do next. So thank you for your time.
Thank you, Ms. Miller. Mommy Preston. Ms. Preston.
Good afternoon.
Good afternoon.
My name is Mommy Preston. I'm a resident of Ward 1. Honorable Chairman Mendelson, council member, and respected members of the community. Thank you once again for allowing me to testify. Over the past year, I have testified repeatedly on illegal and unsafe construction across 3 different directors of the Department of Building. The leadership has changed, but the enforcement failure have not. I'm here to talk about a question that is on the mind of residents across the city. Has the Department of Buildings learned the real lesson from V Street collapse? Let me be clear. Illegal and unsafe construction in the district is not a policy mystery, as Darinka stated. It is an enforcement failure. The after action report of V Street shows this plainly. Before December 23rd, 2024, collapse that tragically claimed a life, the risks were already known. Over excavation, no shoring plan, no 3D monitoring, deteriorating masonry, demolition and excavation happening at the same time, 7 special inspection reports already submitted. And yet, no stop work order was issued until after someone died. That matters because an after action report is supposed to do more than describe what happened. It is supposed to identify avoidable loss of life and trigger mandatory changes to prevent it from happening again. The V Street AAR fails on both counts. It documents monitoring, but not enforcement. It describes communication failure, but treats them as an explanation rather than triggers for action. It relies on administrative bulletin and closed meetings as corrective measure, but administrative bulletins that are sometimes not even publicly available, and closed-door meetings after a fatality are not oversight, they are reaction. And this brings me to why this matters for us today, here in the district. Residents near high-risk construction site like 3644 13th Street cannot answer basic safety questions. Is the site classified as high risk by DOB? Are there identified high-risk properties? Who is monitoring and how often? What risks have been identified? What enforcement action have followed? Are adjacent properties being protected? There is no public record that answers these questions. There is no proactive communication. Enforcement escalates only after tragedy, not risk. So when some say the V Street AAR shows the system worked, I ask, what enforcement threshold was crossed after the collapse that had not been crossed before? If the answer is none, then the system did not work. It's weighted. Council's role is not to write guidance or encourage coordination. It is to require enforcement that is mandatory, timely, and transparent when life safety is at stake. That means enforcement thresholds, automatic stop work order for high-risk condition, mandatory monitoring requirements, public access to inspection and enforcement record. Because an after-action report does not produce enforceable change, is not a preventable tool. It is a record of the inevitable. And unless enforcement changes, the condition that caused the V Street death are still present, just without the collapse to expose them. Council oversight is necessary to ensure the AAR function as a preventive tool, not a post-mortem narrative. Thank you.
Thank you, Ms. Preston. If your statement was written, could you provide it to us?
Absolutely.
Great, thank you. Jonathan Hertz.
Chair Mendelson and members of the council. My name is Jonathan Hertz. I'm president of Historic Mount Pleasant, a volunteer-based membership organization dedicated since 1985 to preserving the architectural legacy of the Mount Pleasant Historic District. I appreciate the opportunity to testify today on illegal construction enforcement and the urgent need to close the enforcement gaps that are harming our neighborhood and undermining public trust. In August 2025, Historic Mount Pleasant submitted a detailed letter to DOB Director Brian Hanlon.
Hey, Sharita, can you walk over there? I'm gonna call you right back, but can you walk over there and tell Vasella
Somebody
to
needs
answer
to
the
turn their
phone?
microphone off.
Let's see, where was I? In August 2025, Historic Mount Pleasant submitted a detailed letter to DOB Director Brian Hanlon documenting serious and ongoing enforcement failures on Mount Pleasant Street, including multiple projects proceeding either without proper permits or in direct disregard of Historic Preservation Office directives and approved plans. These projects are in clear violation of guidelines meant to preserve the architectural integrity of our historic district and principal commercial corridor. The most egregious case at one of the most visible locations in Mount Pleasant, 3215 Mount Pleasant Street. The built work diverges sharply from the permitted plans, including the use of unapproved brick, unapproved window types, and missing upper facade brick detailing, as well as a gigantic gas meter installation protruding onto the sidewalk. These changes are not minor field adjustments. They alter the building's character, erode the historic streetscape, and signal to other property owners that rules are optional. In our August letter, we emphasized that because the DC Historic Preservation Office no longer has a separate inspection program, it's the Department of Buildings' legal responsibility to enforce building permits and ensure compliance with approved plans. We specifically requested that the Department of Buildings immediately investigate the work, hold responsible those carrying out unpermitted or non-conforming construction, clarify enforcement procedures in coordination with HPO, and ensure transparent review and compliance for forthcoming development. These were reasonable, concrete steps aimed at preventing further damage and restoring confidence in the enforcement system. Since sending that letter, we followed up with emails and by phone. As of today, we've received no response, no explanation of enforcement action, and no indication that the department intends to correct the violations. This continued inaction risks setting a troubling precedent that could erode the protections afforded by the historic district designation and have consequences beyond Mount Pleasant. When developers and owners see that visible documented violations in a designated historic district go unaddressed, they reasonably conclude that the district will not enforce its own rules anywhere. This undermines not only the Historic Preservation Office and the Department of Buildings, but also the long-term investments residents and small businesses have made to maintain and improve their properties in compliance with district law. I urge the council to insist on enforceable, transparent, and accountable systems that match the strength of our laws on paper. Specifically, require the Department of Buildings to provide written time-bound responses to community-submitted reports and a dashboard that allows residents to see what complaints have been received and what actions have been taken. Mandate clear coordination between the Department of Buildings and the Historic Preservation Office so that deviations from approved historic preservation plans trigger automatic review, and ensure that major projects, future projects, such as the planned redevelopment at 3224 16th Street, where a developer is proposing a 5-story addition to one of the original mansions built by Mary Foote Henderson, are subject to systemic monitoring during construction. The residents of Mount Pleasant have spent decades working to preserve and revitalize our neighborhood. Those efforts depend on a basic understanding. If you get a permit, you must build what was approved. If you do not, the district will enforce its laws. Right now, that understanding has been badly shaken, and only visible, timely enforcement can restore it. Thank you for holding this meeting and for your attention to this matter. I'd be happy to answer any questions.
Thank you, Mr. Hertz. A few questions. Mr. Jones, so you had a number of points that you made. I sort of got the impression that you sort of were critical of the draft report that we have. Would that be a fair comment?
Not necessarily critical. I think there's some things missing. So I think, and this is something that we've seen time and time again, when we look at how we discuss illegal construction, the majority of illegal construction, unfortunately, is happening on certain property types. But when we talk about illegal construction, we talk about it in a broader scope, and it kind of prohibits the ability to target and make a lot of those substantial changes. And that's what I'm referring to.
Okay, and you, so some of your, I did see we believe it would be more strategic to develop strategies that focus different groups of inspectors on specific property types. Like, I assume that means like single family housing illegal construction. And I may ask the department about that.
Just really quickly, and the reason behind that goes back to construction. While there's certain aspects of construction that are similar across the board, there are certain things that are more targeted towards single family or low-rise properties as opposed to high-rise properties and things of that nature. And if you have folks with that expertise, they can easier find that information.
Yeah, I'm not sure that there's how much differentiation there is in expertise. We're looking for whether there's a permit and whether the work is done within the scope of the permit. As opposed to, for example, an elevator inspector with regard to construction or repair of an elevator has to have technical expertise about the elevator. The illegal construction inspector just wants to know if there's a permit for the elevator. So I'm not sure how much there needs to be that, but I'll ask the department about that. I'm speaking slowly because I'm writing a note. But you also suggest establishing a working group. Why doesn't the business community just establish its own working group, such as what Chuck Elkins has done with some of these residential homeowners who've been victimized?
Because when we've made recommendations previously, they've been shelved. So when the agency actually does it, then that usually creates a report that goes into the government record. We've worked with folks before on this, and it seems to fall on deaf ears for some reason, because maybe we're not specifying problems that we're creating or that we're suffering. Folks don't really want to hear about it, but we've worked with groups before. We've sit on task force before dealing with a lot of these issues, and those reports, they look nice and pretty. They have great covers on them, but they seem to disappear and never get picked up.
You're provoking some of my cynicism. So maybe don't have a nice cover on it and it will be taken seriously. Or somehow you think that a report that's done by a government-sponsored task force will get more attention than one by a private sector task force. Sometimes the government is equal opportunity and will disregard all reports, but that's just me being cynical. It's a good recommendation, so I appreciate that. I had some other questions, so let me see if I can get to those. But that's all I had for you, Mr. Jones. Ms. Miller, Rebecca Miller, when were the two inspectors eliminated, or the two inspectors eliminated from the Office of Planning budget? I should know, but I don't.
The FY26 budget.
So all three positions were eliminated in FY26.
And the chief inspector is now acting as is under DOB. That didn't really pan out the last couple of years as well.
What do you mean it didn't pan out?
Well, they didn't have their cooperative agreement, and so HPO didn't have enforcement authority because they get that authority through DOB.
Okay, so what I think you're saying, maybe I've got it wrong, is there was an MOU between the two agencies, between Office of Planning or HPO and the Department of Buildings. And then there were these inspectors, but they were on the Office of Planning budget?
They were under the HPO budget, yes. Office of Planning.
Okay. And so they were, and in the last few years, what was not happening? That MOU?
Yes, did not happen. So last year,
You know-
my understanding is it was just they didn't have badges, so they weren't able to go and do enforcement inspections. And had to rely on inspectors from the Department of Buildings to do that. And I think one of the challenges in this is that when we're talking about training, is there is specialized work that needs to go into historic districts. When you're looking to see if somebody
Yes.
has a permit or not, that's one thing. But if you're going to see if the windows were replaced correctly and properly fit within a building, that's a different training aspect.
Yes, I understand that. And I'm glad you made that point. But you said that the inspectors in the HPO budget were working out of Department of Buildings.
That's my understanding, yes.
But still, they were free and independent enough that they would go out and inspect historic properties.
Yes. Because so the Coalition for Greater Preservation Enforcement that met back in 2000, or that was 1997 or 1998. This was pre-me, if you can believe that, since I've been around for so long, came together because there wasn't enforcement happening in historic districts. And so they advocated and managed to have their first enforcement officer at the Historic Preservation Office. And then 2 more were added as well, as field inspectors. And my understanding is we do not have those now, that everything is run through the Department of Buildings.
So going back to the golden age when there were HPO inspectors, I said that with a little sarcasm. What would happen if they went out and found that the windows were improper? Let's say there was a permit, but the windows were not appropriate for the structure.
They had enforcement authority, so they could issue a notice of infraction.
And was the owner required to replace the windows?
Not necessarily all the time. It would depend if the owner would appeal it, and if it went to the Office of Administrative Hearings, the administrative law judges there on a number of occasions would just say it was fine, and everybody would move on. So there's where we lack while we had an enforcement mechanism, we also, once individuals or property owners would appeal that kind of decision, it would then make it to the Office of Administrative Hearings, which is why we mentioned that in our testimony, because that is another place that really has, it's a large workload for the compliance officers to show up and do those types of hearings. And then you're going in opposition to the homeowner, and the administrative law judge may not understand why it matters that much.
Well, let me go back. So with the Department of Buildings, so an NOI is issued. Does the NOI require corrective action? And absent an appeal to the Office of Administrative Hearings, the owner is required to replace the window?
In some cases, yes. If the owner will do it, but it's also, there's a lot of times where my understanding, a lot of these questions you might have to ask the Office of Planning when HPO is before you. But what would previously happen is you'd have your notice of infraction. The owner would inevitably reach out to find out what they needed to do. Sometimes they would change, sometimes they wouldn't. Sometimes you have the condition where a building's already being flipped and it's been changed already. The deed has gone to a new ownership and they had no idea that there was an infraction.
Mr. Hertz, with Historic Mount Pleasant, have you ever seen corrective action where there was a work that violated the scope of the permit or work that was without a permit?
Yes, actually. And in the past, the Historic Preservation Office, particularly the one person they have left for enforcement, Tony Cherry, did a great job. They went out, in one case in particular, actually across the street from me, the owner dug out his front yard to build a garage. And now it looks like it did before. There are cases with the windows in Mount Pleasant in general. They have been replaced after they've been installed. And I think it's because the homeowners make the contractors do it to fix it. But there are a number of cases over the years that have been very satisfactory, and even minor things like people put satellite dishes on the front of their houses, and the Historic Preservation Office inspector would come out and tell the owner, you can't do that, and it was gone. And just simple things like that we can't depend on anymore.
Thank you. Give me just a second. Oh, yeah, Ms. Jablo. So attached to your testimony are some pictures. If you could pull them up. I'm not interested in the first picture. I guess maybe that's a worker. The first picture is a worker.
Yes.
The second picture, what am I looking at? Is that the stickers on the window showing that they
Yes.
were replaced?
Yes.
And the third picture, which looks like the entire front of the house, literally, except for the door, is one board.
Right. So I saw this while walking past it. It's on the unit block of 3rd Street Northeast. I reported it to DOB and I was told that this is okay. The entire facade of the house was removed. This is in the historic district of Capitol Hill. This is an historic structure. The second picture after that is just a screenshot view of the Google Street View from July of 2025. And then
Before or after?
Before, right? So
Okay.
this the picture with the fiberboard facade, all of the fiberboard is just a couple weeks ago. The screenshot view of what it looked like before the facade was removed was from July 2025. And then the third picture shows the workers in the process of removing the facade. And that was taken like a week before the first picture. The issue here, though, is that what happens behind a fiberboard, a two-story wall of fiberboard, is unknown. I can't say anything about it. Nobody can unless they go in there. And if DOB has 5 inspectors, which I think is what your report said, and each inspector is responsible for over 1,000 inspections every year, I don't see how they can possibly monitor this in a timely fashion. We've seen this before on Capitol Hill, where historic structures were literally demolished illegally. And, after the fact, it was reported, but by then it was too late. So, I'm not saying that this is happening here. I'm saying that this is an example of how you absolutely need robust enforcement and inspection. And if you don't have it, bad things can happen and nobody can do anything until after the fact of the destruction.
Are these pictures the facade? Is that the 101 5th Street?
No. I gave these pictures of the facade as an example of, the problem with having just 5 inspectors for the entire city.
Sure. What's the address?
I don't know what I'm sorry, I don't have the exact address, but it's in the unit block of 3rd Street Northeast on the west. On the west side on Capitol Hill. Yeah, so it's a 2-digit, it's probably like 17 or 19 3rd Street Northeast. I'm sorry, I'm being inexact because I don't remember what the exact address is. I just use this as an example. It's not, according to DOB, illegal. Okay, so I want to make that clear. But I'm saying that when you don't have many inspectors and you have a 2-story fiberboard facade that has no openings except for a door that has no window, anything can be happening behind it. And without robust inspection, you don't know until after the fact.
Correct. So as far as you know, there was a permit for this building.
According to DOB. I couldn't understand how that could possibly be legal, but according to DOB, it is cool. That was why I reported it, because I thought this looks really sus, to put it mildly. So, there we go.
Okay. Thank you. Give me a second. Thank you, each of you. I have no other questions for you. We will turn to the government now. I do want to say, as the government is coming forward, that all the testimony we've gotten so far has been very helpful. According to the witness list, we have only Nicole Rogers. Come on, the rest of you can show up. She needs company. Give me just a second. Well, it's on my mind. Witnesses who testify today. Ms. Rogers, when you're ready. Although actually, before you start, I'm going to ask you when you're done testifying about that building, Ms. Jablo, I was just asking her about on, she thinks it's 3rd Street. So if somebody can look up what's going on with that building. It's the unit block of 3rd Street, Northeast. Microphone.
I apologize. Without the specific address, it may be challenging, but what we will do is research her name to see if we have record of her submitting that complaint, which may allow us to look into it further on when we went out and what we were able to observe.
Okay, let me look again at the picture she submitted. Do you think you have the address?
Yes, Chairman. We're looking into it now.
Okay, it's really quite striking. It's just I don't know if you can see from there, but the entire front of the house is fiberboard.
Okay. Looking into it.
Okay,
Shall I get started?
yes.
Good afternoon, Chairman Mendelson, council members, and council staff. I am Nicole Rogers, and I serve as the Chief Building Official at the DC Department of Buildings. I lead the Office of Construction and Building Standards, which oversees compliance in the built environment and makes sure it is safe, durable, and environmentally sustainable. That includes permitting, construction compliance, inspections, green building, and third-party inspections. At DOB, our mission is to protect the safety of residents, businesses, and visitors and advance the development of the built environment through permitting, inspections, and code enforcement. In doing so, our mantra is to keep the built environment safe, green, and moving. I want to start by briefly describing how our illegal construction enforcement program works, then speak directly to the findings and recommendations in your recent report on our illegal construction program, and finally detail how DOB is responding. DOB's illegal construction program is the district's primary enforcement mechanism protecting residents, workers, and adjoining properties from unsafe or unpermitted construction. We respond to complaints submitted through our website via 311. When a complaint comes in, our inspectors research the address to determine if there are past violations, active permits, or prior complaints. Illegal construction can mean work without a permit, work that exceeds the scope of a permit, or unauthorized after-hour construction. If illegal construction is identified during a site visit, inspectors document what they see and issue a stop work order, which further stops construction activity from occurring until compliance is reached and outlines the steps the property owner needs to take to come into compliance. In some cases, a stop work order can also result in a notice of infraction or NOI, which is associated with fines issued to the property owner. To illustrate the scale of our activity, DOB conducted 6,189 illegal construction inspections in FY25, a 12% increase over FY24. We are currently enforcing 2,604 active stop work orders and tracking 2,201 unabated violations. Since FY21, we have secured abatement of 2,465 illegal construction violations, which is a 53% abatement rate overall. That number increases to 64% for life safety violations involving damage to adjoining property or unsafe working conditions. DOB received your report, and we appreciate the time and effort that went into that work. We agree with the overarching goal of your investigation to make illegal construction enforcement more consistent, more effective, and timelier. I want to directly address several of the themes you identified and outline the steps DOB has taken or is taking in response. 1, training and staffing. You found that new inspectors could benefit from more hands-on and scenario-based learning, and that staffing levels need to match workload and complaint volume. We agree, and here's what we're doing. We're hiring a field operations program manager to focus on scenario-based instruction, case studies, cross-training, and structured ride-alongs. We are restructuring onboarding so new inspectors move into the field earlier, supported by experienced inspectors. It was also noted that illegal construction staffing levels have not kept pace with demand. We agree that enforcement is resource intensive and that appropriate staffing is critical. Number 2, scheduling, follow-up, and repeat offenders. The report noted that DOB generally performs well on scheduling initial inspections quickly and suggested continuing the KPI of completing 90% of inspections within 7 days. That remains our current standard. The report also raised concerns around follow-up inspections and repeat offenders, especially where inconsistent ownership structures make identification difficult. To address those issues, we are updating our standard operating procedures so unresolved violations receive systematic follow-up inspections rather than relying on additional complaints. We are evaluating system enhancements that would help inspectors identify property owners and contractors across multiple locations, even when limited liability companies or layered ownership structures are involved. We have updated directives regarding no access, so inspectors can issue stop work orders when denied access at permitted sites. This aligns with practices in other major cities, including New York City. These changes are already reducing the number of no access outcomes and improving our ability to verify conditions. Number 3, proactive reinforcement. The report recommends that DOB establish a standard operating procedure for proactive enforcement instead of relying solely on complaints. We agree. In FY25, DOB conducted the highest number of proactive blitzes we have ever done, including blitzes on holidays at the request of an ANC and in areas with high permit activity. We are formalizing this work by developing proactive enforcement guidance that addresses selection criteria, frequency, and documentation. We appreciate your acknowledgement of the deterrent and educational value that proactive enforcement provides. Of course, any mandate to conduct proactive enforcement program should come alongside providing DOB with the necessary resources to execute one. Number 4, notices of infraction and adjudication. Your investigation identified several areas where the NOI process can be strengthened, including service timelines, filing timelines, documentation quality, and tracking hearings and pleas. In response, we have standardized NOI documentation, reinforced photographic evidence requirements, and added quality review steps to reduce deficiencies. We are improving coordination between inspectors, the Office of Civil Infractions, and the Office of Administrative Hearings to better track pleas, hearings, and outcomes. We support the establishment of service and filing performance standards as the report recommends. We also recognize that NOI adjudication involves multiple agencies, and we appreciate that your report highlights the need for additional staffing at OCI and OAH to improve processing times. In conclusion, DOB's Illegal Construction Unit remains committed to protecting the district's people and places from unsafe construction practices. The committee's investigation highlighted areas where we have already begun making improvements and areas where continued investment in staffing, technology, and process modernization will strengthen outcomes. We will continue improving training, field supervision, proactive enforcement, site access, and NOI workflows, and we welcome continued partnership with the council on practical steps in policy, staffing, and technology that will make illegal construction enforcement stronger, more effective for residents, workers, and neighboring properties. Thank you, Chairman Mendelson and council staff. I look forward to answering your questions.
Thank you, Ms. Rogers. Give me just a second. Again, thank you, Ms. Rogers. Can you tell me more about that unit block, that building on the unit block of 3rd Street?
Yes, so we were able to look into it briefly, and what we understand is that it was permitted and it was approved by Historic Preservation. However, the boards that are up is a temporary measure in order to address lead abatement. Apparently, DOEE is looking further into the property, and there's some abatement and corrective activity that's occurring, which led to the boarding of the property.
Okay, so as far as you can tell, there's nothing in violation of the permit.
At this time, yes. And we'll look further into it as well and connect with DOEE to see if we can get additional information as to timelines and what they are requiring of the property owner.
Okay. So you were present when there were some questions. I think you were present when there were some questions regarding the inspection of properties in historic districts. When there is work in violation of the permit or without a permit, does DOB order corrective action?
And to confirm your question, is this specific to historic properties?
Yes.
So we do, so essentially, historic preservation does have enforcement authority to investigate illegal construction activity for historically designated areas. So that level of enforcement is handled by historic preservation. What was shared in the testimony is somewhat new information in regards to what has transpired in FY26.
Okay, well, the testimony was that between the mayor and the council, we removed 2 of the inspectors from the Office of Planning. That would be HPO. And the third, who had been supervisor, I guess, is back to being the only enforcement officer. That wasn't clear to me whether there were any enforcement officers. But there also was testimony that there's no longer an MOU between Department of Buildings and Historic Preservation, and that MOU is necessary in order for HPO to do inspection enforcement.
That's not my understanding. We have had prior MOUs in the past that included information sharing and things of that sort. So I would like to look further into the status of the MOU for this fiscal year and get back with you.
Okay, so if you'll do that, get back to me on that. So going back to my question about a corrective action, you're saying that would come from the HPO inspector, not from a DOB inspector?
That's correct.
And I think, just so we're all clear, or the record's clear, or whoever's watching this is clear, there would only be corrective action with something like windows if it's a historic property.
Correct. Things that are applicable to historic properties.
Yeah. There was also testimony about, I think it was with Mr. Commissioner Ainsley, Commissioner Elkins, that there was supposed to be a meeting last fall between Build Safety C and Department of Buildings, and it got canceled or rescheduled and canceled. It didn't happen. It didn't happen until like last week. Why didn't it happen last fall?
So we have had a series of meetings with the Build Safe Working Group. It's my understanding that a meeting did occur to go over the recommendations. We've had communications with Commissioner Elkins this week. Yes, we did meet. So I wasn't quite clear on what specific meeting he was referring to. So that is something that we can absolutely circle back with him on.
Would you?
Yes.
I mean, I think the meeting he was speaking of was the meeting that didn't occur, and that could be why you're not aware of it.
I'll definitely circle back with him to get clarity.
Thank you. I have some questions for you about training and staff resources. I guess on staff resources, how many inspectors do you think you need for illegal construction?
So that's a great question. And as we think about a proactive approach, we do need to evaluate further the appropriate number of inspectors. And I think one way to do this, which we've started to do, is creating an analysis per ward based on the demand of complaints that we receive. Some wards have higher illegal construction activity than others. So that analysis will help to determine the best number, especially as we consider not just the complaint-based approach, but trying to be more proactive so that we have inspectors designated in these highly concentrated areas.
Somehow I don't like that answer. Why don't I like that answer? Because your testimony was that there have been 6,189 illegal construction inspections in FY '25. Seems to me like that's a good number. Maybe you could look at FY '24 and see whether it's growing in '25. But take that 6,189 and divide it by how many inspections on average you think an inspector can handle per day. You can do that without doing any like big research. And how many work days are there in a year, which is roughly 250, but that's not including, I think it's 260, but that's not including federal holidays. And there are probably other days like professional development days or something. And of course, time off like leave. So however many days, you divide that into 6,189, you get an answer. And then is that the right caseload you want?
I think that's a good start. However,
It's a great start.
yes, I do want to take into consideration, the type of complaints that we receive, which depending on the nature of some of the complaints, additional time may be warranted. So
Sure.
so what you've outlined, I think is a good starting point, but there are some other items that I think we just have to consider to give you the best number.
But I'm just kind of surprised though that the department doesn't have an answer to this now, how many inspectors you need. So I took 6,189, I divided it by 250, I got 28 inspections a day. I'm guessing that if you subtract holidays, but you realize some of those inspections are probably pretty quick, it still works out to about 28 a day. Is that the right number?
I think it's a starting point.
That was your answer before.
It's very dependent on other factors. So I think we can start with giving you that analysis to determine a range. And the interesting thing about the numbers based on the inspections that we've completed in FY '25 compared to FY '24 is we have had some fluctuations and transitions in staff. So to give the best number, doing a deeper analysis, I think would be helpful, and we can provide you with a range that seems ideal.
Yeah, if I'm sounding a little discontent, I am. So if I ask you to follow up with an answer, my guess is the answer is going to go through IQ and it's going to get sanitized because it has budget implications and we won't get a good answer. I'm kind of surprised the department doesn't have a sense of what the ideal caseload is for an inspector.
Well, we have an ideal case, well, we have a caseload, I will say. And currently, I'll tell you, we have 7 inspectors and 2 vacancies. So, and that's just on the inspector side.
So you have 9 positions?
And that's just on the inspector side.
Am I right?
Yes.
That's 9. There's 7 plus 2.
Correct.
And that's for illegal construction.
That's specific to illegal construction inspector. So it doesn't include support staff or a more recent position that we're posting, which is a field operations manager.
Of the 9, are any of them supervisory, meaning that they don't really go out in the field?
Of the 9, they do go out into the field all. Yes.
Okay, so I will take you up on your offer, even though I'm a little cynical here, that you'll get back on a
Absolutely.
better number of how many
Yes.
for illegal construction. Now, illegal construction, I treated as separately the question of how many inspectors you would need for proactive inspections. But
Currently, it would be the same inspectors.
yeah. All right, so you'll get back on the number of inspectors. Of the, let me just see here. AOBA testified about, I thought it was an interesting idea. Targeted inspectors. As highlighted in the council's report, illegal construction in large part takes place in single-family housing or small to medium-sized multifamily properties, with even less occurring in medium to large-sized commercial or multifamily properties. With such limited resources, we believe it would be more strategic to develop strategies that focus different groups of inspectors on specific property types. What do you think?
I actually welcome that approach. We haven't historically taken that approach to illegal construction, but it's definitely something we can explore.
Now, I told Eric from AOBA I wasn't knocked over by this recommendation. So it's interesting your action is different. And the reason is because, maybe I'm wrong, but a illegal construction inspector, he or she is not looking at the technical aspects of the electrical wiring or the technical aspects of the elevator. He or she's looking at whether there's a permit and whether the work that's being done is outside the scope of the permit. So there's work being done on an elevator, but the permit doesn't say anything about elevator. Or there's no permit and all this work is, so I don't quite get why you would need targeted inspectors.
Well, I think it offers an opportunity, as mentioned, to be a little more strategic in certain types of projects. And we do this a bit with our permit-based inspections, where we may do levels of oversight depending on the type of construction activity and what may have been permitted. So it's something that I think with the with the appropriate resources that we can maybe apply to illegal construction. So I do think that there is maybe a strategy in how we could explore that in illegal construction.
So you'll get back to me though on number of inspectors and maybe you can elaborate in that. My understanding is, this is what I want to ask. The committee staff conducted a focus group with the illegal construction inspectors where they suggested that cross-training does not occur frequently. How many department inspectors in other units or divisions have been cross-trained to do illegal construction inspections?
So cross-training is definitely something that we're working to do more of. Even within this year, actually this fiscal year, we completed a cross-training seminar with our Office of Strategic Code Enforcement Inspectors, which includes housing inspectors and vacant property inspectors, where they learned about illegal construction and how to identify it. As part of that, we had one of the inspectors, formerly a housing inspector, to actually be promoted into our illegal construction business unit. There are some challenges there when it comes to the different certifications that would be required. So while we're definitely, I would say, taking advantage of cross-training, we do have some challenges. I want to mention too, our permit-based inspectors actually do also complete illegal construction activity and inspections. So in many areas, we are cross-training our inspectors that we can.
So the electrical inspector is out to look at the electrical wiring and in the process sees that there's a deck being put up and says, hey, I don't see a permit for this. So you mentioned that there was one cross-training, what did you call it? Workshop, seminar?
Seminar, yes.
Only one this fiscal year?
Only one this fiscal year, but we're definitely planning to do more. And that process has already started.
How many more this year?
At least so far, we're planning one, I would say, quarterly to start.
So that would mean a total of 4 this year, at least 4. Correct?
Correct.
one more question. I'm hesitating on this. How does the department determine the frequency by which inspectors are cross-trained? But it sounds to me like you're sort of evolving into that.
That's correct, across our inspection business units.
When do you think you will hire this new field operations program manager?
So thank you for bringing up the field operations manager. This is a new role that we
Yes.
have not had previously, and the position has been posted. So we're looking to hire maybe within 2 to 3 months, which generally is the timing that it takes to do the interviewing and things of that nature.
So I'm writing down onboarding 2 to 3 months.
Yes.
Councilmember Furman?
Thank you very much, Chairman Mendelson. And thank you to our witnesses. I've been listening, and on the historic preservation piece, I guess my understanding, and it worries me, but these things happen, is that we may be in a pretty serious gap where your understanding was HPO is authorized to do this work, so DOB isn't doing the work, but HPO doesn't have the staff to do the work, and so it's not happening. And so that's my fear here. And then the question is, what do we do? And I think pretty urgent that we figure out, if anybody's minding this store, what steps are you going to take to figure that out?
So we do have a good relationship with HPRB. They are a sister agency that we've worked with for quite some time. So I definitely want to circle back with them to understand what this transition fully means for them and how we can support. One of the things that we can do is complaints can come to DOB, and there may be opportunities where we can further support to complete those illegal construction inspections. So I would like to coordinate with them to see how best we can help during this time.
Okay, so I hear you, and just encourage a sense of urgency on it.
Yes.
Chairman Mendelson was asking you how many inspectors, and he kind of alluded to the fact that you can't say because you don't know how many the mayor's going to give you. You probably have an idea of how many you want, but I'm not pushing you on that. But if there is in this coming budget going also to be an obligation to be doing these historic preservation inspections, then your workload is larger than you had previously considered. And there's a year gap where it may not have been done. So I'd encourage you to build that into whatever requests you make to the mayor for increased inspectors.
Yes, and I have with me too my deputy chief building official of inspection, so he may be able to provide additional information here.
So Councilmember Froman, thank you for your question. I think it's a great opportunity for us to grow in the illegal construction side. The Historic Preservation Office is the one that has the authority to enforce the HPO regulations, and we don't have that authority. And I know that's not the answer you want to hear, and it's something that maybe council can help us with. Additionally, the resources that it would take to also enforce from the DOB perspective for legal Office of Civil Infractions, and that aspect of the component would require additional resources for us to accomplish that mission.
Yeah, I mean, I have a sense of urgency about figuring out how, if there is a gap, that we fill it. And I regret that here in a public setting, we may have identified a gap that someone might take advantage of, and we don't want to see that happen. So let's work together to get that solved. And everybody is trying, but there are circumstances where terrible things happen. You saw public witnesses today whose homes have been devastated, or the home that they purchased was deeply flawed from the start. And then there's the question about how do we address the harms done to those people? And one of the witnesses suggested that in Maryland and Virginia, that there is a portion of the fee that is set aside for a fund to reimburse people who have been harmed by failures of the system. And I wonder what your reaction, if you've looked at what's done in Maryland and Virginia, and if you have a reaction to that suggestion.
Thank you, council member. That was interesting, and I did hear that in the witness's testimony. And it's the first time that I've heard of that type of approach. And, I do think in some ways that it could be helpful to individuals that have experienced some of the things that our witnesses have. So that's something I want to look further into. To see how that fund is set up and how certain fees are deviated. So it's something I would look into.
So let's look into it together with the committee, because
Appreciate that.
Maybe that is a thing that can help. And it breaks your heart when you hear the stories of people whose lifetime investments, savings are lost in these things, and we don't want to see that happen. Bad actors. The report has some recommendations about things that might be done. Director Hanlon has wanted to get at bad actors. How have we done? Have we had any contractors who have lost their licenses or had licenses suspended or been penalized because they were repeat offenders in this illegal construction space?
Thank you for that question. It's a great question. And we have really been working towards creating better mechanisms to track bad actors and repeat offenders. Even within this last year, we've actually upgraded our main platform that we use for administering our illegal construction and permitting activity. So first, establishing that mechanism to make sure that we are properly identifying these individuals is what we're starting to do. We've made several referrals and started the process to investigate certain bad actors where we are aware that they have been associated with properties for multiple violations and things of that sort. I will say one thing that has remained a challenge that we're still working through is tracking LLCs and being able to kind of uncover if they have, acquired another LLC and are, again, doing business. One of the things that we are starting to do is actually applying liens, property liens, to properties where, there is a developer that we've been able to identify that have had multiple illegal construction activity, so that they do not try to transfer that property, so that a new owner then, is left with dealing with coming into compliance.
Yeah, I mean, the corporate forms are a challenge. And another thing that needs to be thought through together is how do we get through those things so we make sure that it's not a wolf in sheep's clothing. And so that's important. One of the things one of the witnesses mentioned was this is swell for general contractors, but if they're not a general contractor and not licensed in that way, do we have a way to get at them through these kinds of tracking mechanisms and referrals to DLCP? Do you have a reaction to that?
As much as possible at the permitting stage, we're requiring individuals who are associated with the property and that are doing permitting to be registered in some form or fashion, whether they're a permit expediter, a design professional, or general contractor, so that we can start to develop that tracking mechanism. So that's one of the first things that we started to do at the application stage, so that it is easier to identify them down the line. So if something were to happen, we can hold them accountable. I think some of the challenges happen too, because majority of our stop work orders that are issued are for work without a permit, is being able to truly track down these individuals when they don't submit a permit application.
Yeah, I think what Mr. Elkins was getting at is it may be somebody who's a subcontractor who's not on the permit, who's not listed in that way, may not be licensed in the same way, but you could have a subcontractor who is turns up repeatedly. And how do we get at that?
Well, this is where, working with DLCP is essential, because even subcontractors must be licensed. So that's something that I think we definitely need further coordination with. I have with me Keith Parsons, who is our strategic enforcement administrator, and he may be able to further talk about some of the actions that have been taken to refer these bad actors.
Certainly. So, pardon my voice. I've gotten the seasonal affliction, as it were.
Sorry to hear it.
But yeah, we do work very closely with DLCP, and we do refer these types of cases as well as other types of cases. The basic challenge is the same for all levels of these types of bad actors, which is that we need to connect the bad actions to the specific actor, and then they need to be licensed in a way that DLCP can take enforcement action against them. So if we can line up those three things, then something can happen. Different challenges come up if it's someone who isn't licensed, if it's just a money person who owns a bunch of things, but the actual folks doing the work are not that guy. That can be additional challenges, but we are working on it.
Okay, thank you very much. Mr. Chairman, I have two short questions. Can I do it and then leave you to your devices?
Yeah, actually, you'll leave me to Councilmember Bonds, but go for the questions.
Okay, thank you very much. One of the recommendations is where there's lack of access for an inspection for illegal construction, that should be immediate stop work order. Where are you on that?
That is actually in practice currently.
Okay, then we'll get to Councilmember Bonds that much more quickly. I don't know that you'll answer this question specifically. Another one of the recommendations is that we need more ALJs. We talked about needing more inspectors, but we also, there's numerous choke points and numerous places where it breaks down. What's your reaction to the recommendation that we should increase the number of ALJs to deal with these things once you guys have found an infraction? And the question you won't answer, how many do we need?
So I absolutely agree with that recommendation. I can't speak to the number needed, obviously. That is outside of DOB. But the sooner we can help to resolve many of these through the administrative process, I think the better.
All right. Again, thank you very much for your testimony, Chairman Mendelson, staff. Thank you so much for the work you've done in this area.
Thank you, Councilmember. Councilmember Bonds, did you have some questions?
Yes, thank you very much. And thank you, Chairman, for this hearing. It is right on time, I guess, when we're all inside primarily and poised to learn a little more about how we can fix this problem. In fact, I'm more concerned with how we fix this. It is great that we will have perhaps more inspectors, but how do we how do we change the atmosphere in the District of Columbia that leads individuals to believe that illegal construction can be done and done without any harm to community, and it's just about a pocketbook. And I've heard a lot today about the stop work orders, and that seems to be the one system that we use to determine what we can do. But I'm asking really, what about this climate? What are some of the other things that perhaps the inspections unit has identified as the reason why we have pretty fragrant illegal construction in the city? And I thought Ms. Rogers may have some insight on that.
So council member, thank you for your question. I want to make sure I understood your question. And is your question to help further identify why we have
Yes,
illegal?
that's the question. You've already identified the fact that we have numerous stop work orders, and I would imagine you look at that as some indication of things that must be wrong, and therefore we can anticipate that if we have a lot of stop work orders, then the work may not be as legal as it needs to be, or as safe. So I'm wondering, are there other things that happens in our environment that the inspectors maybe have noticed? And I asked that question, like, for instance, I went to one site a couple of years ago, and the construction was happening next door to a row house. And the digging of the basement was by permit, but it didn't take into consideration the fact of the age of the old brick structures and the fact that there was water. And so the house next door, which was still standing, people living in it, was caving in. And I just wonder, are there things like that that have been noticed, maybe in certain areas that are going on where we give a permit and the permit somehow becomes a permit to do whatever you want? I just don't know. And so I'm asking those questions then.
Thank you for elaborating. So some of the things that we see out in the field, and I'll name a few different type of circumstances generally that we see. One is someone is fully working without DOB's approval. So they're working fully without a permit. And, you know, it has subsequent consequences. And then we're also seeing where people have a permit, but they are exceeding the scope of that permit. For instance, and this is something that we framed our inspection blitzes around, is we have postcard permits essentially that are for minor scopes of work. For instance, someone may be able to pull a permit for interior demolition. And the permit has a very specific defined scope of work. However, what we find is that generally people will get that permit posted and then continue to proceed to do work outside of that. They exceed that scope, that very refined scope that they were allowed to do, and do more work.
Okay, so then when a permit is issued for work, I think we can make it more tailored. It just seems to me there is some language that we can add to the whole permitting system. I am interested in curtailing the amount of illegal construction that we have. I appreciate that we have inspectors. That's the only way we will know what is going on. But I think our goal has to also be to end this process in this urban area where so many people can get hurt just from a faulty construction site. So that's my question. I also wondered if your inspectors have a sense of certain neighborhoods, maybe the age or the type of structure. Back to Mr. Jones's concern. Eric Jones was concerned about having inspectors that do a particular type of structure, and wondered if there's any need there that we need to look closer at.
Thank you, council member. There are a couple of things too that I want to mention to also respond to some of your first question. And that includes, one approach that we are working towards is making sure that we better educate the public on things that they should also be on the lookout for, so that as much as possible, we can visit these areas early before any dangerous activity occurs. Making sure that we educate our public on things that do require a permit. And one of our approaches in being more proactive when it comes to illegal construction, given the resources, is to actively stay in the field in these particular areas where we know there is higher or more frequent activity of illegal construction. And also, I mentioned the exceeding the scope of what we have when it comes to postcard permits. One of the things that we've done is we've reevaluated the scopes of work allowed under those type of permits to refine it and make it very clear and limit what type of work would be allowed moving forward. So just wanted to also add that to your first question. To answer your second question and also the comment from Mr. Jones, I think that is definitely something that we want to explore. And, we can start to look at, some of the, which we're already starting to do, I will say, permits that are issued for high risk structural and excavation work, making sure that we do frequent oversight inspections. Within the past year, we've hired a special inspector where, based on the permitting activity that we have, we're able to have this inspector to go out and observe activity, and often unannounced, to actually ensure that when work is occurring, it is occurring in accordance to the plans and that it is compliant.
I appreciate hearing that. And the excavation is one of the most troubling areas. And I wondered if we need, with the permit process, to make it clear that if you get a permit to do excavation, that there will first have to be an inspection so that they see the soil, and that the inspection is ongoing through the digging up of this ground, because I think that's where a lot of the problems exist. We're at least that's what I've heard over the past few years. So I know I'm running out of time. I will not take the liberty that my colleague did. So, Mr. Chairman, I'll turn it back over to you. And thank you, Ms. Rogers. You've given me a little more insight. Thank you.
Thank you, Councilmember Barnes. While inspectors who were interviewed by the committee staff said that they know of some repeat offenders who engage in illegal construction work, we found that the department lacks a formal mechanism to track repeat offenders. This is along the same line of questions that were asked by Councilmember Fruman. Your testimony suggests that the department is evaluating system enhancements to help inspectors identify property owners and contractors across multiple locations. My first question is, how long does it take to figure this out? Because this is an issue that I've raised since the days of DCRA.
Thank you, Chairman. So one of the things that we have started to do is, during the permitting stage, our plan reviewers are working closely with our inspectors. So if through the permitting process, if a plan reviewer sees on the plans that this professional engineer has stamped these drawings, it looks familiar. I've witnessed that they've maybe I would say, been in violation of illegal construction previously. We need to go out to this site before work takes place, before we grant them a permit to verify site conditions. So that's one of the things that we're doing internally to make sure that we verify activity for individuals that are repeat offenders. Systematically, in upgrading our platforms, we are exploring functionalities that allow for better tracking of repeat offenders so that when a stop work order is issued, not only are inspection business units aware of the activity, but on the permitting side, we can also ensure that there's no further permitting activity until the stop work order issues are resolved, and that we apply a higher level of scrutiny as this individual moves forward through the permitting process to ensure that the work is compliant.
So there were two parts to your answer. The first was internally, was you're looking at the permit application or the drawings that you might identify somebody. I would think that wouldn't happen very often because the drawings are by an architect and the architect isn't the one who's out there exceeding the scope of the work. I would think that would have limited results. Not that you shouldn't do it. I think it's good. But the second part of your answer was consistent with your written testimony. We are evaluating system enhancements that would help inspectors identify property owners. Evaluating doesn't really tell me anything. This, as I said, has been an issue that I brought up every year going back to DCRA. And so how long is it going to take to figure this out? Evaluating systems, how long is it going to take to figure this out?
Well, one of the challenges that I mentioned too in my response with Councilmember Fruman is being able to make sure that we connect the dots between the LLCs. Oftentimes what happens is the owning entities will create another LLC and move forward with permitting and other activity, which makes it difficult to track.
I understand the difficulty, but I would think that heads could get together and try to figure this out. So what is evaluating system enhancements that will help inspectors? What does that mean in terms of time?
What we have done and continue to do is with the information that we have with licensed individuals like contractors and design professionals and agents for owners, which often we refer to as permit expediters, is we're able to, at least with that information, be able to draw connections and determine if these individuals are repeating multiple levels of illegal construction activity on one project. We're looking at other projects that they're associated with to ensure repeat violations and things of that sort do not occur again.
Is that what you mean by a system enhancement?
Well, with technology, I think it will help us to better track many of these things across different business units.
Okay, so you're looking at some IT improvements.
Yes.
Okay, has that work begun?
Yes, it has.
And how long is it going to take?
So we have upcoming meetings with our vendor to actually explore different functionalities. We even had a meeting this week. So I can get back with you on a definitive timeline.
I'm a very slow writer, but I just wrote down, we'll get back with a definitive timeline. Now, my plan B would be that I could always have another hearing. I've discovered that sometimes hearings are a way to make things happen quickly. So please get back and I'll look at your answer. Could you at this time answer this question? What would these system enhancements look like in practice?
I can share an example
Okay.
if that is helpful.
Yep.
So one of the functionalities allows for our inspection units to create conditions for approval. And this can directly tie in to when a stop work order is placed on a property, to when someone comes into compliance or attempts to come into compliance for the permitting side. Right now, some of our challenges are visibility and being able to see whether a particular permit applicant has had prior stop work order activity. We have worked internally to create data and metrics to tie in individuals with stop work orders. And if an inspector is able to tie in conditions leading or as a result of a stop work order, this allows further cross coordination within our agency to ensure that compliance is reached through the permitting process and addresses the cause of the stop work order. And also we're able to really capture individuals that may be associated with that project. But again, this goes back to the information that we already have, which would be when someone is licensed as a contractor or a design professional or registered with us in some form or fashion.
A crazy thought just crossed my mind, which is that you could, as a condition of a stop work order, require that the permittee, if there's a permit, disclose all the individuals. So you don't normally ask that?
We do ask that currently, but as you stated, that's if there is a permit.
Yeah. Do you know if these system enhancements will require additional capital funding?
I do not have that answer yet, but I will definitely get back with you as we have more conversations with our platform vendors.
During ride-alongs and interviews, the committee staff found that gaining access to construction sites is a significant issue. I think you spoke to it. There's been testimony about that today. The report recommends that you adopt a policy of issuing a stop work order when an inspector is denied access at a construction site with an active permit. Your testimony confirms that the department has updated standard operating procedures to incorporate this recommendation, but this only addresses access issues at sites with permits. A lot of construction is done without a permit. Given this, what happens if someone who is doing unpermitted work denies an inspector access to a site?
So in practice, if we visit a property and they don't have a permit, but we see evidence of construction, we are going to issue a stop work order. We want to be able to capture that property owner's attention so that we can compel them to allow us access to verify conditions. So whether there's a permit or not a permit, if we see any evidence of construction activity, we are going to post a stop work order at the property.
And you would do that if you don't have access to the site. How would you do that? On the perimeter of the site?
Correct.
Okay. Of course, ideally, you still want access because you want to see what's going on.
And this would be used as a tool to gain access, to capture the property owner's attention, to contact us.
Well, only if you follow up quickly, which I will get to. But what if you don't see evidence of work? So the most obvious would be you show up at the site and you see some workers. Clearly there's some work going on. You can check to see, your inspector can check to see if there's a permit, but they also would go and interview the workers and find out there's not a permit. But if there's nobody around, so there's nobody who's doing work, so it's not really clear that there is work going on. Maybe, think so, but not really clear. What do you do?
So I'll mention that we will make at least three attempts to gain access. And this may include speaking with neighbors who could have seen or heard activity. So as much as possible, we make every attempt to gain access to the property.
And this is all part of the inspector's training
Correct.
to know to do this.
Yes.
Okay, so they knock on my door and I say that, yeah, there was work going on there this morning. That's sufficient for you to issue a stop work order.
So that, I will say, it will require further investigation and review. One of the things we may also do is figure out what information we have for the property owner and try to directly contact that property owner to gain access.
Does that really happen? The inspectors who've got 28 inspections a day, they have time to do that?
Correct. It does. It is in current practice today.
Is there anything the council should do to address this issue?
Additional staff and support staff, I think, is helpful because typically when we do receive complaints, we do have to do a lot of research. And this could be before or after we complete our inspection.
Of course, you have to get back to us on. Your testimony notes that the department is updating standard operating procedures so that unresolved violations receive systematic follow-up inspections. Now, the work of the committee staff, we found that follow-up inspections were conducted on average 77 days after the service of an NOI. In some cases, the follow-up inspection did not occur until 115 days or longer after the service of an NOI. So 77 days is 2.5 months, 115 days, I can't do the calculation, maybe that's close to 4 months. That's a long time. Things can happen in a week, maybe even in a day. In the revised standard operating procedures, is there a time frame for when these follow-up inspections must be conducted?
So I want to first address this question by clarifying that we have different types of follow-up inspections. So there may be a follow-up inspection in cases where, the first attempt to inspect is resulted as no access, for instance. And then there may be a compliance inspection. So once a stop work order is issued and the property owner contacts us, we create a compliance path for them that includes steps that property owner must take in order to come into compliance. Once they have come into compliance by completing those steps, they're required to follow up with us to schedule a compliance inspection. So follow-up inspections can vary. There are different timeframes that we apply to creating follow-up inspections. So in the cases that are referenced in the sample, it may be the case that they were compliance inspections, confirming that the property has come into compliance after they have completed the necessary corrective actions.
Did you want to add to what you were saying?
Well, I can add that, as I stated earlier, the different types of follow-up inspections, one being the compliance inspection, and then another that can systematically occur when perhaps we haven't heard from the property owner, where we're going out to make sure that the stop work order placard remains in place and that it wasn't removed, unauthorized removal, I should say, and to ensure that site conditions remain safe and that the property remains secure. Compared to a compliance inspection, which could be where someone has to obtain a permit to come into compliance, and it may take time for them to obtain the necessary documents and go through the permitting process.
I have to say, I'm not sure I like that answer. And why don't I like the answer? Because we're talking about stop work order because the work exceeds the scope of the permit, or there is no permit, especially when there's no permit. I think it's a critical issue, and we've heard a lot of complaints that the illegal construction will just resume. So I'm not asking about a follow-up inspection to see if it complies. I'm asking about a follow-up inspection to see whether they're violating the stop work order by still working.
Right, and that's why I wanted to provide that clarification that we have different types of follow-up inspections.
Okay, but what we saw was that on average it was 77 days. I don't know whether that's a compliance or an any, but it was, I don't know if it was a compliance inspection or an anything inspection, but still 77 days is 2 months. Well, there was one witness who testified that I think it was Ms. Jablow, that they just the next day started working again. And they apparently did that repeatedly, where the guys would come back out and then they would just start working some more. And that it's waiting any period of time other than like maybe 24 hours seems to me waiting too long.
So I believe in the report, the sample data is referring to the compliance inspection and not an actual follow-up inspection confirming such activity as far as monitoring whether the stop work order was violated in any type of way. So I would like to further look at that sample data to ensure that and get back with you to confirm based on what our data shows, which I believe is different.
Okay, I'm going to put down that you're going to follow up. I'm not quite sure what you're following up. So I would like to know what the average is for coming back out to ensure that there was not work that resumed.
Yes, understood.
And it was also part of my question, in the revised standard operating procedures, is there a time frame when these follow-up inspections must be conducted? And my guess is that the answer is no.
So we're creating systematic follow-up inspections, which are again based on the nature of the stop work order. And these timeframes are being assessed based on that. So ensuring that the stop work order remains in place and that there is no further activity occurring in violation of the stop work order, and ensuring that the site is maintained in a safe and secure condition. So those are things that we have in place. I'm sorry, I apologize, that we're working to have in place and that will not be triggered from a constituent making a second complaint.
Sure, I get that. And I think that's
Yes.
good. But my question still was, is there going to be a time frame? Like within 30 days?
Yes.
Within 40 days?
Correct.
Okay, again, I'm making a distinction between the inspector just going back out there to make sure work hasn't resumed,
Yeah.
because compliance is different.
Correct.
Maybe there's compliance with not working and there's compliance with
Coming in.
applying for a permit or revising the permit. And I'm asking about the former, and you're going to get back to me.
We
My
agree.
impression is that they're not coming out. And you think they are. So you're going to tell me how soon after the stop work order is issued is to follow up to ensure that no work is being done.
And let me clarify, we're implementing a mechanism to automatically schedule these follow-ups. So depending on the nature of the violation, for instance, if there's a violation of creating an unsafe condition, we may follow up within 7 days to make sure that the property is secured and maintained in a safe condition going forward. So that I believe is what you're also referring to
No,
in the type of follow-up inspection.
no. I am tempted to go back to Ms. Jablow's testimony where she testified that on a property, you all came out, said there was no permit, issued a stop work order. The next day, the workers were back out there.
Yes, I understand. And we're creating systematic follow-ups where a follow-up inspection will automatically be scheduled once a stop work order is issued. And that timing could be, just throwing an example, 7 business days or 3 days, depending on the nature of the violation. And this would be something implemented going forward.
Yeah, that's still not leaving me satisfied.
So,
So why not?
Mr. Chairman, if I may, what we've done is we've recently been able to fill some of the positions that we've had in the OCBS management, and which has allowed us to now focus strategic versus being tactical. One of the implementations that we've just completed with the inspectors is all stop work orders now receive an immediate correction order. And the correction orders provide a timeline for the owners or the applicant to come into compliance. The correction order provides a path, and a follow-up inspection will be completed within the time frame within the correction order. That's different from the way the system used to be, where we would just issue a stop work order and then wait for the owner to send in a
Sure.
request.
But I'm still getting at a different issue, a different aspect of the issue. I'm looking at Ms. Jablow's testimony. Now, this is several years ago, so this is before any of your tenure, I think. Weeks later, after it was purchased, this rooming house in the historic district of Capitol Hill was illegally gutted without any permit. Neighbors reported it repeatedly. Even after the agency documented gross violations and issued stop work orders, after police escorted workers away at least once, and after the agency cited the owner, work continued. During this time, I was photographed in my own yard by the owner's workers. That's what I'm getting at. So we're not talking about any compliance order or compliance. We're talking about stop work order was issued and the work continued.
So in what we're implementing now, this were applied then, what would happen is we would issue the stop work order, and then we would come back out immediately maybe 2 days afterwards, an automatic follow-up inspection where that inspector will go back out shortly after to make sure that that stop work order is maintained and that there is no work occurring.
Well, now that was the answer I was looking for.
Yes.
So,
I apologize.
and that's going to show up in your standard operating procedures as well?
Yes, it will. So what we're working to implement is to make sure that follow-up inspections are automatically scheduled. And these timelines that we're going to establish are determined based on the nature of the violation. So in cases like the example that you provided, there may be a shorter window that we're going to complete that follow-up inspection.
Okay, I again said there were 77 days. You said you don't think that's correct. So you're still going to follow up?
Yes, and I will follow up confirming whether that was a compliance inspection. And I apologize if I may have caused any type of confusion there, but if it was a compliance inspection or just another inspection to verify activity.
All right, I'm way over my time. Councilmember Bonds, did you have any questions?
Yes, thank you. I just have, just want to follow up a little bit. Now I recognize that my issue of trying to eliminate illegal construction is probably not going to happen, and we don't have the wherewithal to prevent it. So therefore, I wanted to follow up on this issue of the stop work order, if I could, Ms. Rogers, and wondered if do we as a government have the capacity to fence in these locations where there is a structural unsafe condition issue that has been cited, so that we can be assured that no work takes place until the owner, the construction company, comes forward with their plan of how to remedy the situation?
Thank you, Councilmember Bonds. I want to also just make sure I understood your question. In cases where we have cited a property for unsafe conditions, you're asking if we have the authority to go out to secure the property.
I am asking if we, and when I say we, I mean our government. There have been discussions with you, with the Department of Buildings, and perhaps DHCD, who at one time was doing the boarding up of unsafe structures. Just wondered, where are we in this? Because it sounds like we believe we're going to solve the problem simply through inspections, when to me, it's a little deeper than just the inspections. Because if you cannot go back on a regular basis, like every other day, to see what's going on a site, and you only have 7 inspectors, or 9, hopefully, then we're at loss. You're talking about a great volume. You said 6,000 in illegal construction inspections in FY25. That's a hell of a lot of visits by 7 individuals. So I'm just trying to understand the extent of the problem and how we might really adjust and come up with solutions once and for all that would send a message to those who believe that they can use illegal construction to get by, and at the same time provide safety in the community. So that's where I am, and that's what I'm trying to understand. So I hope that I have explained myself a little better to you so that you can give me some feedback. So thank you.
And thank you for elaborating. And I do want to, I'm going to also ask Mr. Parsons to jump in, but in cases where there are unsafe conditions and the property owner has failed to respond or act in a timely manner, we have, as DOB, abated those type of violations to, as much as possible, secure the property. And I'm going to turn it to Mr. Parsons to kind of talk about that process.
All right, and will he talk about what securing the property means? Because that's what we're talking about.
I would be happy to, Councilmember, and thank you for the question. So the basic answer to your question is yes, DOB has the authority to secure properties. We board vacant properties routinely. We sometimes fence properties. But there's a big qualification. The qualification, of course, is that this costs money and itself takes time. So yes, if we believe that there is a property that needs to be fenced to protect the community, we have the ability to do that. But the nuisance abatement fund is not going to be so large as to allow us to fence, every property with a stop work order or something along those lines. So it would become pretty prohibitively expensive, but it's a tool in our toolbox.
I hear what you're saying. And so my thought, of course, was not that the abatement costs would be an expense that the government would bear. It would be borne by those that get a permit and then violate the permit.
Yes, council member. So it is, you should think of it as an expense that the government advances. So it would then be placed as a lien on the property. And theoretically, we would get that lien money back. And historically, we have a pretty good return on those liens eventually. So it's not going to happen until the property conveys. And if it's a true problem property that sits as a stop work ordered construction site for years, of course, during all those years, we're not going to get that money back. But yes, we can place a lien on the property for the costs.
All right, and it seems to me we can go further, not just place the lien on the property, but if the property sits vacant for, let's say, more than 2 years, it seems to me we can talk to the CFO and think about how the property can change hands so that we can recover our money and that the community can have a decent property again in their community. I just feel that this is bigger than the Department of Buildings from what I've heard today. And I'm very concerned about how we are attacking this issue, which has been around. I know I began to hear about it in 2016, 2017 through my housing committee hearings. So I'm just really hoping that we can move a little faster on these issues because we have a tremendous need for residential development across the city, and in many instances this can help us with it. And even if it's a commercial property, there are places across the city where residential can be atop of commercial properties or as such. So I'm just really wondering, I'm hoping that we are going to put forth some real solutions that will make a difference so that we can improve the quality of life again. So that's the nature of my concern. So thank you very much, Chairman, and thank you to the representatives from the Department of Buildings.
Thank you, Councilmember Bonds. A few more questions. The committee staff found that several NOIs in the sample you provided were dismissed by OAH because they did not contain the correct citations, contact information, or appeal information. Additionally, several NOIs were flagged as deficient by the department's Office of Civil Infractions because they lacked photographic evidence. Ms. Rogers, in your testimony, your statement, you said we've standardized NOI documentation, reinforced photographic evidence requirements. I'll start there. What does that mean to reinforce photographic evidence requirements? If they're required, they're required. So how do you reinforce that?
So when an inspector issues a stop work order or any type of notice, they're required to upload critical documentation, supporting documentation that is later used for OAH and other purposes. And there is I would say, formula, if you will, or template that is necessary for which the inspector must provide these documents, making sure that the violation is noted, making sure that the picture is clear, things of that sort that our Office of Civil Infractions will verify through their internal review. So I'm also going to lean on Mr. Parsons here, who oversees our Office of Civil Infractions, and he can further elaborate on what the requirements are for uploading information.
Thank you, CBO Rogers. So the Office of Civil Infractions does review every NOI that gets filed. They have to, in order to provide essential documents, that are used to file the document at OAH. They'll review everything other than the sort of substantive judgment call, and that's because they can't check the inspector's judgment call, but they can say, you know, hey, is there a picture for the violation? Have you filled in all of the information so that all of the boxes are populated? Do we have all of the, you know, necessary documents to file? So when, and we do have a process, it's a pretty long-standing process to, if civil infractions finds anything missing, that's when you'll see that flag defective, and it goes back to the program to correct the defect, and then it's filed as normal. So a lot of times it's things like missing pictures, which again, civil infractions can't fix. If it's something that civil infractions can fix, they just fix it and the filing moves on. Otherwise, it goes back to the program, they fix it, and then it's filed.
Now, it was Ms. Rogers' testimony. We have reinforced photographic evidence requirements. So what does that mean?
So I'll jump in there. So we have actually done retraining with our inspectors to make sure that they're uploading things properly, including photos, ensuring that they're capturing the actual violation in their photos. So that's a part of our reinforcement. We also have developed reporting mechanisms that allow us to be a little more proactive when we receive defective cases from our Office of Civil Infractions. I want to note that within the past 2 years, because of many of these new mechanisms, we have seen a reduction in overall defective NOI cases. So much of this is retraining our teams, making sure that things are documented, and making sure that people are aware of the necessary protocols in providing the supporting documentation.
Still, what the committee staff found was that there were cases that went to OAH that were dismissed because of inadequate documentation. So how is this happening? If it's going through this review process, this internal review process, how is it happening that then OAH is saying, is dismissing the case?
So I think the sample data may have skewed some of the metrics. In our raw data, what we found actually is that the number of defective cases that are referred to back to the program actually come from the Office of Civil Infractions, which is based on us doing our internal audit and QA.
Sure, but that wasn't my question. There are cases that OAH is kicking out because of inadequate documentation.
And I will ask Mr. Parsons to jump in, but I wanted to kind of reiterate that number on the sample data appears higher than the overall number of NOIs that are actually referred back to OAH, from OAH.
Mr. Parsons?
Thank you, Chairman. So OAH does, of course, dismiss some cases, I guess, against our will, if you will. And sometimes we do make mistakes. So I'd be happy to look at any particular case to see what type of situation it was. When we were looking at the report, I was kind of trying to dig in there and wasn't able to clarify any of the exact cases myself. But sometimes mistakes get made, and sometimes we just think OAH gets it wrong. It can happen.
You don't keep track of how many OAH cases are kicked out because of inadequate documentation?
So it is harder than you think, Chairman, to actually pinpoint why a case is dismissed, in part because we dismiss a lot of cases ourselves. If we get a settlement or some other resolution, usually the last thing we do is we clear it out of the OAH docket to make room for other cases. Sometimes the OAH judge doesn't say a whole lot about why they're dismissing a case. But to answer your question, we do have an analysis that's trying to track why things get dismissed. I don't have it in front of me, and it's relatively recent, but it's not as exact a science as you might think.
So you'll provide me with that analysis?
I'd be happy to, Chairman.
Okay. I'm a little confused why it would be difficult if the information is being recorded. So I'm not asking about cases that, NOIs that the Office of Civil Infractions kicks back to the inspector. I think that's a worthwhile line of inquiry because it suggests that the inspectors need some training, need to improve what they're doing. But I'm not pursuing that line right now. I would think that it's not that difficult and that the department would want to know what's happening with the cases that are going to OAH. So you would be tracking how many are dismissed because you asked that they be dismissed, how many are dismissed by the OAH judge, and that within that number, you would want to know how many were dismissed because of something that the department failed to do as opposed to the evidence.
Understood. I completely understand the question, Chairman. And I just want to be clear that sometimes the final order looks the exact same for some of those outcomes.
Sure, but how many folks do you have in the Office of Civil Infractions?
I believe we have 8.
And among those 8 people, this is an unfair line of question. This is, I mean, a snotty line of question. But among those 8 people, there isn't somebody who can pay attention to the OAH cases. How many get adjudicated a day or a week at OAH? I'm guessing it's not even a handful.
It's about 50 a week.
50 a week?
It comes and goes until, it's as many as the court schedules. But we do, in fact, try to track this. I'm just trying to set expectations, Chairman. It's
Well,
not an
my
exact
expectation is high.
Yeah, well, I was strive to meet it.
You were trying to lower it. No, my expectation is high. I mean, we really should have just a hearing with regard to what's going on with OAH and the NOIs, because that's been a bigger issue in my view with the housing inspections. So I'm looking forward to your following up with an analysis.
Be happy to, Chairman.
So I have a longer question here, which I'm going to shorten. With housing code inspections, the department has established an alternative resolution team to negotiate settlements with customers to achieve case resolution without going to OAH. Is this a process the department is using or could use with regard to illegal construction infractions?
We do currently use it for illegal construction infractions and cases.
Is it new that you're doing that?
No.
Mr. Parsons, since I guess Office of Civil Infractions comes under you, so you probably would be the person who would meet with OAH or with the chief judge over there? Have you?
No, Chairman. Our Office of General Counsel is the direct liaison to OAH.
And how often does OGC meet with them?
I want to say it is at least quarterly and maybe more frequent, but we can check on that for you.
Yeah, would you? And follow up, are you invited to those meetings?
I have not been. My understanding is that OAH likes to structure the meetings in a way that they make sure they're not engaging in ex parte communications.
Well, that makes sense, but unless you're talking about a specific case, maybe your general counsel is. I would think there's a value of just talking to them about how they're scheduling cases, how the schedule is more or less burdensome on your inspectors, what the chief judge is seeing with regard to the kind of evidence that Department of Buildings is providing or not providing. None of that's ex parte. I would think that you are at least as important as your general counsel with that, because the administration comes under you.
I agree, Chairman. All of those things are important. I would love to discuss them directly with the OAH judges.
All right, so you'll follow up, elaborate on this.
Yes, Chairman.
Do you know how many attorneys who handle OAH cases the Department of Buildings currently has on staff?
So we currently have 7 line attorneys on staff, and they don't solely handle OAH cases. So they handle a diverse portfolio of issues, which include OAH handling. There is also 1 attorney that is being onboarded. So this would account for a total of 8.
Thank you. So you are going to get back to me with you're going to get back to me with a definitive timeline on developing this evaluating system. And you're going to get back to me on the status of the MOU with HPO, or explain why it doesn't exist. And you're going to get back to me how soon after the stop work order is the follow-up inspection to ensure nothing more than just that there's no work being done. If there was more that was going to be elaborated, can you get back to me an analysis of why, the analysis you've done on why cases are dismissed at OAH? And get back to me on more information about your Office of General Counsel meeting with the OAH chief. I think that includes how often, why you, Mr. Parsons, wouldn't be included. And if there's anything else you said you were going to get back on that I didn't read, add that to the list as well. I do not have any other questions for you all. I know you'd like to be here another couple hours. I think I saw 2 of you the other day, although not in the room. I think it was a virtual meeting. Maybe, I don't think you were here, Mr. Parsons. You were off that day, or you were let off by the committee. Thank you. That's going to conclude this hearing. This has been a hearing on illegal construction enforcement, gaps, and recommendations. I want to thank all the witnesses who've testified. The record in this matter, which I did not say at the outset, will be open for 2 weeks. That is, it will close at 5 p.m. on Friday, February 13, 2026. The time is 3:15 p.m. and this hearing is adjourned.